All right, so the way we conduct the meeting is we try to keep it quiet while we're going through it. If anybody needs to speak while we're going through the meeting, please feel free to go out into the hall and do so, okay? I'm hard of hearing, and I want to make sure I hear every single word that's spoken by everybody here this evening. Having said that, this is the regularly scheduled meeting of the Yarmouth Zoning Board of Appeals this July 11, 2019. We have 4 matters on our agenda this evening, and the first is number 4785. Whoever's on that petition, please come up to the table. Whoever is presenting that petition, please come up to the table. In accordance with an order of remand in Land Court Case Number 19, Miscellaneous 84, the Board of Appeals will conduct a public hearing on petition 4785 Gabriel Lopes, 28 Pockenecket. Did I say that right this time, everybody?
Yes.
Wow, I'm getting better. Drive, South Yarmouth, Mass. That property is located in the zoning district R25. This evening, our applicant seeks a special permit under zoning bylaw 202.5, use table, paragraph P7A, to operate a home daycare. Good evening. Would you identify yourself and tell us what you have to say about the petition, please?
Good evening. William Eads, attorney representing Ms. Lopes on behalf.
All right.
this
With you
petition.
is Ms. E.
Sorry.
Go ahead, please.
I do have a letter in support from Cape Cod Child Development that they wish they could come today, but they only gave it to me today. Would you prefer that now, or?
You're welcome to bring it up now. Sure.
Okay.
Yeah. Our new rules require us to mark everything you submit as an exhibit. Do you have one for everybody? All right. So I'll pass those up and down. I'll mark the first one as Exhibit 1. Thank you for your records, counsel. That's, what's today, 7-Eleven, right? 7-Eleven. Reminds me of a little convenience store once it went to. Go ahead, tell us all about it if you would.
All right. So, and I noticed you're very busy today, so do you want...
Listen, we're here to take all the time you need. So
Well,
feel
since this is a remand, I didn't know if you really need me to cover some of the factual background or whether I can just jump right into the argument on it.
Well, as far as I'm concerned, you could jump into the argument, but I
Right.
think that we have a lot of people here. Can I just have a show of hands on who's interested in this petition this evening? All right, as I thought, there were several people. So I think,
Who I think were all at the previous hearing.
I'm not going to get into that.
Okay.
But, and you know, in fairness to those people, why don't you give us a short presentation, if you would, of what relief you're seeking, and then what has happened since we last considered this? Okay.
Okay, what has happened since you last considered this? Okay, so Ms. Lopes operates a family daycare out of her home. She is duly licensed by the state, got her license from the, I keep getting the EEC, which I keep forgetting what that stands for, early education, right?
Yeah, early education material.
In July of last year. And then there was a complaint against her in October of last year, at which time there was I know this was discussed at length at the previous hearing, a process that eventually led to her applying for a special permit to operate the daycare because she wanted to be in compliance with the town zoning bylaws. At that hearing, you all denied her application. It since has gone up to the land court, who remanded it back down here for further hearing. Is there anything else I should be covering as to background?
Well, why don't you tell us what it was that the land court felt we needed to have another hearing for? What was the reason? I mean, again, this is your petition. You're presenting it. I'm not here to tell you how to do it, but
That's
I think
fine.
it would be helpful to this board if we heard what
Sure.
you want to tell us about what occurred.
So the
why
land,
the land court decided we needed to have a further hearing.
my understanding, and I'm sure Mr. Winter could share his understanding if he cares to, is that the land court felt this had not had a complete hearing in the original hearing, and that certain aspects, specifically the importance of the Dover Amendment in relation to how the approval for daycare facilities in towns and the importance of them was considered here and sort of, I should say, not considered in the previous hearing. So I guess I'll just jump right into my argument then. Basically, the Dover Amendment says that in respect to this specific situation, my understanding of it is that it says that family daycare homes should be allowable unless specifically zoned or regulated by the towns. Yarmouth chose to put in the rule that a special permit be required for family daycare. So the only thing that should be in consideration here then is whether the requirements of the special permit are met, whether this is likely to cause hazard, nuisance, congestion, or substantial change, or risk of substantial change to the character of the community. And I believe in the previous hearing, the major argument that came up against the granting this permit was that some congestion would be caused due to the usage of Pockanacket Drive, an unimproved and, frankly, hard to notice part of Pockanacket Drive that I've driven by twice now as I have toured the area, which is just not the case. The actual access to Miss Lopes's part of the duplex in which she resides is located on Wampanoag Road, a road that is a full paved road. I think it's probably full width. I didn't actually get out with the measuring tape, but it's certainly approaching it. And that is access to, it's very close to hotels, beaches, a full commercial district. It seems to carry a fair amount of traffic, and the addition of at the moment, 3 cars that visit Miss Lopes's daycare on a regular basis over the space of a few hours in the morning and probably the space of an hour in the afternoon, stopping for, what did we say, 2 minutes maybe for these. They don't exactly linger. These are busy people who want to have childcare available to them. And that hardly can be said to add congestion, hazard, or nuisance to the area. As the chairman, as you yourself brought up at the last hearing, the operation of a daycare home in itself cannot constitute a nuisance. Children are not a nuisance. This is again pretty busy when I toured around it. Family, summer, community. In terms of access to the roads, there's a lot of cars parked on the roads. Actually, Ms. Lopes, as I stated in my brief, encourages her clients, and if the board requests, can absolutely demand of her clients that they park inside her driveway, which can support all of her clients at one time if they were to ever show up at the same time, not that they ever do. And but when one does tour around this community, you see dozens. I was there last week touring around. Dozens of cars parked on lawns, sides of roads. This is not a change to the character of the community or any out of the ordinary congestion, even if someone did park on the side of her lawn, which, again, they try not to. So basically, I think we would contend that there is no hazard created by the operation of Miss Lopes's daycare. There is no nuisance. There is no congestion, and there's no change to the character of the community to have children there who are within her home. And I can answer any other questions you like. I know there was a lot of discussion of the fitness of the home last time, which I would say is really a matter for the state licensing board, who has re-licensed her or conducted her annual review and found her home again fit to operate a family daycare home within last month.
Well, let me stop you there. You'd
Sure.
agree that the licensing board has nothing to do with this board's grant of a special permit, right?
I do, but I also would say that based on the reading of the Dover Amendment, the purview of this board is whether a special permit can be granted, and the board's decision should be based on whether it creates hazard, nuisance, congestion, or change the character of the community, and the operation of the daycare within the interior of the house is not part of that.
No, my point is only that the grant of a license by the Commonwealth of Massachusetts
No, it
that
does
this
not
is an
does not
appropriate
entitle you
daycare
to this.
is not a de facto grant by this board.
I don't
In
disagree.
any way influences this board. All right.
I think it should.
I think we kind of get a gist of it. Did you have anything else you wanted to say?
As I said, I'm happy to answer any other questions you might have. I think I've covered what I'd like to in my brief, and I hope you had a chance to peruse.
Because I want to make it crystal clear, we're going to hear each and every bit of evidence that the petitioner wants to hear this evening, if she felt she didn't get that opportunity last time, okay? So we do have, and I think it's probably appropriate to now call, if you're done. For the time being, I'm not saying you don't have a chance for a rebuttal.
Yes, exactly.
Brian Winter is here, Brian Winter Esquire, who represents the town in this matter, and Mr. Winter was part of the land court proceedings. This matter comes to us by way of a joint motion for remand in which there are specifics that were offered to the land court, and those specifics are that there were discussed and identified additional issues, both legal and factual, which were not previously addressed by the plaintiff or the board. These discussions have resulted in an agreement that those additional matters warrant further hearing by the board, ostensibly to try to change our minds as to our prior decisions. So, Mr. Winter, why don't you tell us what you perceive occurred up in the land court on behalf of the town, and then where we stand tonight?
Happy to, Mr. Chairman, and that's an excellent segue. First of all, let me introduce myself. Good evening, Mr. Chairman and members of the board, and also to the members of the public. My name is Brian Winter. I'm an attorney with Town Council's office. As you eloquently put it, this matter was before the land court after the last decision of this board, and that resulted very quickly in an agreement for remand. Now, I want to stay on that point just for a moment because I want to elaborate on something counsel said for the applicant, and that's that the only hearing we had before, and it wasn't really even a hearing, it was a case management conference, as we call it, before the land court. And the reason I'm highlighting that is because that's a housekeeping conference. It's not a hearing on the merits of the case. The merits are sort of discussed to give the court an idea of what the case is about. But it's not an opportunity to argue the merits of the case. And the reason I'm pointing that out is because this was a joint motion that we presented after counsel and I conferred about the posture of the case. It's not an order of the court in terms of a decision on the merits. The court didn't hear the merits, didn't issue any instructions to the parties other than what you have before you, which we wrote. And didn't decide anything. So there's no order or judgment from the court that comes along with this. The reason why that's significant is because you have a fresh case before you. It didn't come back from the land court with any instructions to do this, not do that. Now, the other 2 points which you touched upon, Mr. Chairman, are why did we do that? We did it for 2 reasons. One is in the conversations I had with counsel, it was represented to me, and it's part of the complaint that they filed with the land court, that perhaps certain factual issues didn't get fleshed out completely or accurately or fully. At that time, Ms. Lopes was not represented by counsel, and perhaps there were some factual issues that the board would benefit from hearing more on, or that the applicant in this case, would enjoy an opportunity to flesh out further. The second element was a legal element, as you referred to earlier, and that's that after reviewing the board's minutes, the board's decision, and the applicant's presentation at the first hearing, there was no mention of Chapter 40A, Section 3.
I'm sorry?
There was no mention reflected in the decision or the minutes of General Laws, Chapter 40A, Section 3. Now, the first thing the land court might ask is, did the board consider it? What's its position on it? So one of the reasons why I suggested that the board may review this again is so that we could cite that provision, which specifically addresses family child care homes, and that could be incorporated into the board's decision. Now, you have before you in the paperwork exactly what that provision states, but I'll just read it out loud so you can hear it from me. Family child care home and large family child care home, as defined in Section 1A of Chapter 15D, shall be an allowable use unless a city or town prohibits or specifically regulates such use in its zoning ordinances or bylaws. So here, of course, the town does that. There's a special permit requirement, and you have criteria attached to that. So this is an opportunity not only to flesh out the factual record, but to consider each and every one of those special permit criteria, as required under 40A3 and the specific paragraph concerning family child care homes. So that's my summary of the land court posture, and I'm happy to answer any other further questions as they may come up.
Very good, thank you. All right. Do you intend to call anybody at this time,
I don't.
or to add anything beyond, in light of Mr. Winter's comments?
I guess the only thing I would clarify is I mentioned the Dover Amendment and forgot to mention, as my colleague did, that that's Chapter 40A 3. I just forgot to mention the site, so that was the same thing. So
Okay. Well, then let's open it up to the public's commentary and input into the merits in favor, those people speaking in favor of this petition 4785. Please come to the microphone and let's hear what you have to say. And seeing none.
So-
Now let's open it to those people who might speak in opposition to this petition 4785.
Oh, I
Please come to the mic.
would you like to? I know in the past you've read letters into the record. Would the
gonna do
letter is in the okay
I'm gonna
in
do it. I'm not
favor?
gonna-
Okay.
I've got one new letter from what I can see. It's dated July 5, 2019, and I'll be happy to read it now or at the
No,
conclusion.
I meant the letter I provide you from Cape Cod Child Development is a letter in favor that I just gave you.
Is-
As I said, they were late in providing it.
Yes, this one here, Mr. Chairman.
Oh, I'm sorry. Okay. Yeah, I'll read both of them.
Yeah.
Okay, that's all right.
Whenever
I see
you'd like
someone's
to,
hand. I don't
yes.
know whether you're speaking in favor or against. Which way is it? You want to speak against? Okay. So going to that lectern would be difficult for you, would it, or would it be all right? You can get over there? Okay, don't race. And if you're uncomfortable doing that, we can get a seat.
No, I'm just
All right.
a little bit feeble, but can't take
You and me both. But I do ask you to tell us who you are and where you reside, please, sir.
Let me apologize at the outset. My hearing aid broke. I have no idea what anybody said.
Me too.
And if I'm redundant, please throw me out of here, okay? My wife and I own and live at the property on 8 and 10 Pockanocket.
Could you tell us who you are?
I'm sorry?
Could you tell us who you are?
Oh, I'm sorry. Stan Gravelin is my name.
Thank you.
We've owned the property since 1978. A lot of love for Yarmouth. Over the years, it's been rental, vacation, all that. But as of 2 years ago, we totally refurbished both sides, inside and out, and we now are living there full-time on both sides and absolutely love it. We've even, in the process of doing some landscaping, my kids put in some raised gardens, and they hung out a sign that's called Pockanocket Farms, which I think is pretty cool. So we love it there. We have a vested interest in the neighborhood in keeping it a nice neighborhood like it is. We don't think a business belongs in there. Our objections are that we should not have a business there. We want a peaceful neighborhood. Our property does not abut there as the place of interest here, but maybe I'm trying to support the people it does. And secondly, I worried about the traffic that might go in front of our house. Having said all that, are you Mrs. Lopes? Yes. I respect your hard work and what you're trying to do and the value you would do for people, and I will accept whatever decision we make and wish you well.
While you're there,
Thank you.
sir, before you leave, is this coming through okay?
Yep.
Okay, while you're there, would you just stay for a moment because some of the board members may have a question of you
Yeah,
in
go ahead.
light of what you've just told us about? Okay? Mr. Barron?
Not at this time.
All right, and Mr. Nicanello?
No, sir, I'm all set.
Mr. Igo?
Not at this time, thank you.
And Ms. Britta?
No questions, Mr.
I have a question, if I could. You've referred to additional traffic. Is that correct?
Yep.
And what additional traffic have you observed, and when have you observed?
It's just, it's a dirt road, it's unimproved, and it's true that they can get to their house through a different road, but with the computers, cell phones, I think that's what they'll do, so,
So how long have you been living there full-time?
for 2 years now.
And how often have you observed additional traffic that's caused you concern?
Not much.
Not much. They've been
You're going to
there
ask me how much longer I'm going to live there?
Yeah.
That's not fair, but,
All right, well, they've been there for a year. Do you agree with that?
I'm sorry?
My understanding is this daycare has been there for a year, and you haven't observed much traffic as a result, huh? I'm not trying to put words in your mouth. I'm just trying to understand what you had to say. So, in the year that you've observed this, that you've been living there, and this daycare has been there, there hasn't been much additional traffic
No.
from your observation?
No.
Okay, thank you. Thank you. Who else would like to speak? I saw several hands. Who else would like to speak in opposition to this? I suggest, why don't you come right up to the microphone so we can move this matter along, and whoever's behind that person who wants to speak, feel free to come up. We're not looking to repeat those things that were said previously at our last hearing, but we are looking to give everybody a chance to speak. Good evening. Would you tell us
Good
who
evening.
you are?
My name is Dick Kelly Yancey, and I live at 1 Wampanoag, right opposite the property. And basically, when you asked about that road, I would mention to you the fact that within the past 6 months, they have widened the road and they have leveled the road a lot. So there will be much more traffic now than there would have been during the period that the gentleman has previously been there, because they've leveled the road, they've taken down some trees.
Who's
and,
done that?
The DPW.
Oh, they have?
Yes, within the last 2-3 months.
Have they made it easier for travel than along that road?
Oh, yes, yes. I used to go there that way all the time, but then it got waterlogged and very difficult to maneuver. But now they've leveled it all off.
Have they graded it with? Have they
Yes.
tarred it as well?
No, they've graded it, but
It's hard pack.
not with whatever you call that.
Okay.
Okay. And I would like to say, for all the previous reasons that I have mentioned in my letters to the board, I just don't feel that it is a proper place. If it was a larger property with more room for the children and a fixed fence, I could, and it is. The traffic is, in and out with people dropping them off, and there is a truck domiciled there in the evenings, and I don't know, whether it's a business that's being run there or not, but I have pictures on my iPod that show. I don't think the space accommodating for children is adequate. I don't know about the inside of the house. Whether I would think there would have to be a bathroom on the lower level. And
Well, let me interrupt you just for a second to say to you, that's not our purview.
Oh, okay.
There is in fact a licensing authority here in Massachusetts that gets to make the determination, not us.
Oh, I didn't
as to
realize
whether
that.
or not the particular location and the facilities are appropriate for the care of children, and if so, how many children at that location. We have nothing to say about that.
Oh, okay. I didn't realize that.
Now, are you Ms. Yancey?
Yes.
Okay. So I'm not going to read. Would you rather? Are you okay if I don't read your letter?
Oh, yeah. That's all right.
All
I
right.
just wanted you to know I still oppose it.
Very nice. Thank you very much.
Okay.
I'm sorry, Ms. Berta. Did you have any questions? No. And Mr. Igo? Mr. Nicanello?
All set, Mr. Chairman, thank you.
And how about you, Mr. Barron?
Just a comment that Ms. Yancey said, there's no paving on the
On the
with
dirt
the-
road. No.
on the dirt road.
On
Okay,
Wampanoag,
thank
there
you.
is, but not on
That's
the
all.
dirt. Okay.
Thank you. And who else did I see? Somebody else? Please feel free. Come right up.
Yeah. No, I don't know. not lately.
Robert Goslin, I live on 15 Wampanoag.
How are you, sir?
Pretty good. I have a question first. I don't know if you do it. In the petition here, it's a 202.5 P7A. I don't think many of the people know what that means.
It's a use table applying to child care centers.
Okay. What's the terminology on it? It's a family daycare center or a family daycare?
Gee, I don't know the difference.
Well, there is a difference.
Well, why don't you
because-
explain it to us then?
Well, I don't have it because I didn't read the rest of it.
Oh, okay.
But I did go down and I read it. And under there, if I may have read this wrong, the number of children is only 6. The number of children are 6. Hours of operation is in that law. I believe there's square feet of the playroom for the children. And if there's going to be other employees, it states in that chapter. And if her children, and this is only my opinion, but another one in there is if she's going to collect payment for the daycare, it violates 202.5 P7A.
Okay, well, this is being referred to.
So I may have read it wrong, but I think I did a quick reading and some of the points. Now, just to follow up on our road, that road has been a dirt road for years. Secondly, it floods out every year. And even the mailmen have to change their route. They just recently, within the maybe 2 weeks, they came in, leveled it off. It's nothing but a dirt road, which will flood over and over. Also, as far as the traffic, I live right on the street. I have a big window, and I count the cars going by. The attorney over there went by the area on the July 4th, or the weekend after, where all the families came down and a rental started. However, after August, those people aren't parking on the roads or in their backyards. It was a peak season that he went by and took a look. Because all the traffic comes up from Gateway. Okay, now, Red Jacket closes. People don't go to Short Drive, they come in through Wampanoag and go down through Gateway because the gates are open. But then they close the gates for the summer season. So during that summer season, we got a car coming by about every 2 minutes. Now the vehicles that they're relating to that's in her yard is a paint truck, and I think there's 2 other vehicles in the other apartments, which there's a rental apartment over the garage, and then there's, I believe, down below. And the reason I know that house is because I was my real estate agent, and I've been in it. And it's very congested over there. Right now, I'm dealing with another problem. I've got traffic across from me because there's an unlicensed daycare center going on. And it starts at 7 in the morning, and at 4:30, 5 o'clock at night, it's nothing but a traffic jam. So I'm against that. Secondly, also for the conditions that the children would be in. I went by, there were 3 children out there, no supervision. And the kids were hanging on, it's barbed wire. Well, not barbed wire. It's like chicken wire. And the kids were hanging on the chicken wire looking out at Wampanoag. Now, that isn't right. It's a dirt ground. There's 1,000 toys. And it's not even a thing to look at. I know that doesn't come into it. But I'm definitely against it. And I think, before you grant anything, I think each one of you should go down and take a ride and take a look. Thank you very much.
So before you leave, I just want to express to you,
Yeah.
P7
Yeah.
Daycare Center is daycare center.
Well, I thought
This is, wait a minute.
Go ahead.
Wait a
Go
minute.
ahead. Yep.
I was very polite.
Yeah. No.
P7A is family daycare home. That's what they're seeking relief on.
Exactly. That's the article I read.
Well, but that's different than a daycare center by the numbers
That's
that
right.
can be
You're
in
absolutely
attendance.
right.
Sure. Okay.
You're
we-
right. The daycare, family daycare, is different than the other one.
No, family daycare doesn't mean the care of your family members. It means what's defined by Commonwealth of Massachusetts
Well, whatever.
statutory
I know
law.
what I read, and I may be wrong, but anyway,
Okay.
I'm against it.
I understand. Anybody else wish to speak in opposition, please come right up to the microphone. We have a full house tonight and a lot of people that want to talk. And I promised my bride I'd be home by midnight.
Hi,
Hello.
my name's Anita Gaudette, and I live direct on 23 Pockanocket, directly across the street from them.
Good evening.
And I don't understand where the lawyer gets that the road is fine. That road is never fine, and people do park on that road, and it's very hard for me to get out of my driveway. And that road floods all the time, and it just looks nice now. But wait, give it another month or two if we get rain, and you're going to be back in the holes.
You mean after the DPW repaired it?
Yep. They do it. This is the third time, and I've been there 20 years.
I got you.
And this is the third time they've repaired it. And that's my concern. I don't need people parking across from my driveway where I can't get in and out.
Can I ask a
And as far as the daycare,
You feel free to ask anybody that comes to the microphone.
Okay.
anything
No,
you'd
I
like
let
to
her
ask.
finish, though. Sorry, I thought you were at the end.
Go
of
ahead,
the
please.
end.
and as far as that place she has for the kids to play, it's all dirt. Those toys have been there for over a year. And it is chicken wire, and I don't think children should be out there in that.
Well, again, I want to make it crystal clear that this board's consideration has nothing to do with the quality of the facility. We have no right to even stick our, in my case, big nose into that. That is a matter for the Commonwealth of Massachusetts Board of Licensure to control, not this board. This
Okay.
board is charged only with the issues relating to zoning, okay? And I'm sorry, I wish we could be an all-everything board too, but we can't. So we have to consider only that which we are charged with doing. And the gentleman may have a question, please.
I was just again, as people have pointed out, I'm not as familiar with the neighborhood as you are. When you talk about the road that's flooding, we're talking about Pockanocket, the section of Pockanocket Road that is unimproved, correct?
It's the road would be from my house, which I'm directly across the street from her, to the end.
That's the section of
The sea
Pockanocket
view,
Road, yes. Okay. So we're not talking about Wampanoag Road.
No.
Okay. Thank you.
Okay, thank you. Anything else?
No, that's it for me, thank you. Sure, please, sure.
You live right across the street, ma'am?
Yes, I do.
And have you observed cars at different times of the day dropping
Yes.
off and picking up?
Yes, I have.
And do you know roughly how many cars on a given day would, say, drop off?
Well, lately it's only been about 2
Okay.
or 3, but I'd say a month or 2 ago, there was twice that many. There was quite a few.
And are they at specific times of the day?
No, they're different.
They're different, so
Yeah.
all...
In the morning and then pick up at night.
Okay. And do they pick up, what time at night do they pick up?
Well, I haven't really noticed. I'm not sitting in the window watching them. I'm not that interested in them, so,
Okay, thank you.
okay.
Anything else?
No.
I apologize, I didn't offer you that.
Okay.
Thank you. Anybody else?
I assume I'll have an opportunity to respond to a few things.
We're going to
later.
absolutely,
Yeah,
offer you the opportunity to respond. I'm asking, does anybody else in the audience wish to speak in opposition to this petition? This is your chance, so come and take it. You're going to absolutely be able to speak before the board deliberates.
Hi. My name is April Regolinski. I submitted a letter, so I stand by what I submitted for that. I actually live at 33 Pockanocket Drive, so
You
directly
submitted a
across.
new letter?
No, I did not
Was
submit
it
a new
read
letter.
into the evidence before?
I'm not sure. I was not at that meeting. I
Okay,
could not
so
come.
if I assure you, we read every bit of
Okay.
correspondence that wasn't read, every bit of correspondence for which there was not a like person wishing to speak.
Okay. I also just wanted to add, too, that I live directly across the street, and we do have difficulty getting in and out of our driveway.
Why?
And because of the additional cars. And then also...
Does that occur, if you would?
I'm sorry?
When does that occur?
When does that occur? It's in the morning, and then I think I've seen the pickup probably yesterday it was probably between like 4 and 5. But also you have to understand that it's Pockanacket is here and then Wampanoag is here, so it's actually on a corner. And if cars park outside of her driveway, which I've never seen them actually park in the driveway, cars have to go around those cars, and it's right at an intersection, which is dangerous because they're coming down the other side. And if you have to go around the other cars, you don't know if you're going to get hit from either side on either end. So it can become dangerous if you take the corner, especially when you're trying to go around cars, and then if cars are parked on the other side of the street, to thread yourself between other cars is what I'm trying to say.
Well, hearkening back to the first meeting we had on this petition, I think that was the board's biggest concern, if my memory serves me.
Okay, I'm sorry, I was not there and
Oh,
I
no,
didn't read
no,
the
I'm-
transcript, so I just wanted to make sure that that
It's fine.
point was made here, and to support what other people were saying, to lend my voice to that. So that's all I have to.
Okay, before you leave.
Yes.
Okay. Does anyone on the board have a question they'd like to put to the?
No, but I have been there several times, and I do agree that that corner is a...
The microphone,
it-
please.
The corner is fairly congested.
Yes.
I do, and I've gone it several times, at different times during the day, to see if the time made a difference, and it is congested.
Yeah, it's always congested.
So I just wanted to comment on the fact that I do think that's an issue, Mr. Chairman. Continues to be an issue.
Okay, anybody else? Mr. Igo?
Could I ask, what time of the day do you observe these automobiles?
I mean, recently, I think it's in the morning, probably between, 8 and 9, possibly. I think yesterday afternoon it was between 4 and 5. Today, before we left here, it was maybe between 3 and 4:30, something like that. I mean, like I said, like the other, I think, gentleman said, we're not sitting at the window tracking who's here. I mean, we go in and out at our property as well, so... but you do notice it when it's a hazard to try to thread your way through all these cars.
Well, when was the last time you observed the cars?
I mean, they come there every day. So there's parked, I mean, they were going in and out of the driveway today, this afternoon.
Observed them today? And you know the number of cars that you observed today?
No, I don't.
Could I ask that if somebody wants to speak, that they go outside and have their conversation and come back in?
I mean, there was probably 2 or 3 cars. Like I said, I'm not sitting at the window tracking the number of cars. It's not like I sat there and tracked it in preparation for the hearing.
So you don't have a number of cars that you...
No, but she does have a license for 6. So the potential is, if you grant her the special permit, she has the option of having up to 6 people there coming in and out, and 6 cars. If she's saying that they're all picking up within 1 hour time period, then all 6 of those cars have potential to be parked on that road that you now have to go around and have a hazard for that, and also make it difficult for all the 2 neighbors, because we're right next to each other on Pockanacket, to get out of our driveways, and also on Wampanoag that is opposite, because it's a corner lot, and so you have at least 4 neighbors that are directly affected by it. So that's all I wanted to say.
That's all I had.
Mr. Nicanello? Mr. Barron?
Nothing at this time.
Can you tell me, have you yourself been inconvenienced by not being able to pull out?
Yes, actually, I've had a foot problem, so actually my father drives the car, but he has been inconvenienced going in and out of our driveway, and
You've
also going around.
Have you?
Yes, I've sat in the car when we've had to have that issue, and when cars start, going fast down that road, careening around the corner, and then not like getting scared that all of a sudden we have to stop because you could get hit, and not noticing.
Okay. Mr. Eads, do you have any questions of this person?
No questions. As I say, I'll respond to a few things people brought up after they've spoken, if that's all right.
I'm going to give you every chance you
Great.
want to speak.
I think there's
as long
just-
as time
yeah.
as you want on this petition. I just want to know, some of these people I know would like to go home.
Oh, yeah.
And
Oh, I don't plan on being much longer.
And
Yeah.
then let them on their way. Jeopardy still might be on by the
Yes.
time they get home. so.
I don't plan on being much longer. I just have a few
Oh,
specific
you
things.
take all the time you
Yeah.
want. Is there anything else you wanted to
Nope,
say?
that's all I
Good.
wanted to say.
Anybody else want to speak? And seeing none, we now close it to the public's commentary on this. I do want to read into the record 2 matters. One, Ms. Yancey spoke and she said it wasn't necessary to read her letter, so for brevity this evening. There's a letter dated July 10, 2019 from Cape Cod Child Development, to whom it may concern, by Nancy Sorbo, the longtime director of that facility, and very thankful Nancy's there. I am writing in reference to and support of a Board of Appeals petition to Gabriel Lopes, who is a contracted family child care provider with our agency, Cape Cod Child Care Development Program. Gabriella Lopes is seeking a special permit to operate a small family child care program that was licensed and monitored through the Massachusetts Department of Early Education and Care. This model of daycare, occurring within a home-like environment, where early educators are licensed and trained to provide loving quality care to young children, typically preschoolers, toddlers, and infants, is a critical child care resource greatly needed. Our agency works successfully with a total of 40 family child care providers across many Cape Towns, all of whom are operating in residential neighborhoods very similar to that of Ms. Lopes. Our hope is that there would be thoughtful consideration by the Board of Appeals as to the importance of Ms. Lopes' child care services that support working families in the Yarmouth community. With an open-minded approach to developing a plan to address neighbors' concerns, with the understanding that Ms. Lopes would have an ongoing responsibility to communicate any specific parking requirements to parents of children in her daycare, it would seem there could be a collaborative solution to be found in this circumstance. Citing the reasons described above, I'm asking the town of Yarmouth to strongly consider granting a special permit that will enable Gabriella Lopes to continue to serve the needs of children and families through their family child care business, and again by Nancy Sorbo. Is there anything else, Council, you wanted me to read in?
No.
All right.
Don't
Now,
believe so.
you've heard some complaints on behalf of
Yes.
those people that are abutters and have an interest in these proceedings, and
Sure.
certainly now is your time to tell us anything you'd like to tell us in,
Okay. Well,
in opposition or response.
Just a few things that popped out to me. Do we need to get into the 202.5 P7A thing, the specific zoning bylaws reading of what a family daycare home is, or does the board is pretty clear on that?
I'm pretty comfortable.
Okay, good.
Could I just ask?
Somebody else might need.
Oh, sure.
Sorry.
Could I just ask a question of council?
Absolutely.
Before we go there, because I'm reading your case management conference report you and our council submitted, and your position is that the applicant was not offered an opportunity by the ZBA to reply to material incorrect statements and assumptions made by the parties in opposition at her hearing.
Correct.
So that's pretty specific. So that's kind of what I wanted to hear from you. What specifically, relative to that, would you like to say?
Okay. Well, some of them are ones we're just heard some of them again. Ms. Slope's clients, and she can attest to this, and they've all confirmed, they don't use the unimproved section of Pockanacket Road. They never have. I do agree. When I put her address into my navigation thing, it does try and send you down Pockanacket Road. However, as I said earlier, I've driven past it twice without even noticing the entrance to the unimproved section because it's not obvious. And the obvious thing, and the thing all of her clients do, is go down Wampanoag Road, which is just at the beginning of this neighborhood, and they don't blow around the corner, I think, as was described. They go to her house, which is right there on the corner, as you described. You've seen the intersection in question, and in the pictures I provided, you can see that Ms. Lope's driveway has access on both Wampanoag and on Pockanacket, on the improved section of Pockanacket where it is paved, where they can go in, drop their children off, then go back out and go right back out Wampanoag Road. So that was one of the big things that had come up as an incorrect, I can't see into your minds. I watched a recording and saw you guys did deliberate everything, but there was some significant suggestion that the unimproved section of Pockanacket Road was being used by her clients. The other thing is the amount of traffic we're talking about. Would you like to just briefly go over sort of the daily schedule of cars that come in?
Yeah. So I have I can watch 6 kids, but I have a 1-year-old daughter, so technically I can only watch 5 because she is included.
I think you told us that.
Yeah,
last time.
so I can only watch 5. So the maximum that was ever there was 5 cars. For the past 3-4 months, it's only been 3 or 4 cars, and they come in the morning. They never go through Pocahontas, never, and I make sure they don't. I always tell them that. But on their first visit, when they come in, I say, don't go to Pocahontas, and they don't really want to go through there either. It's a dirt road. So they come through Wampanoag, and they come in the morning from 7 to 9. That's usually their drop-off time. They park, and they drop off their kids less than 2 minutes. They literally they don't even come into my house. They're just like, here's
Do
my
they use
child.
that driveway? Do they use the driveway?
So I have some that do, and some that just park because the daycare play area inside my house has a door, and it's like right there, and they park right here, which is very close to the door. So
Basically on the end of her driveway.
yeah, basically
On the lawn and driveway, I
So
believe.
what they were talking about too is, she said that we blocked her car, but she's on Pocahontas. Nobody ever goes there on Pocahontas. They park right here, which is not blocking anybody. If it was to block anybody, it would be maybe on a Wampanoag, never on Pocahontas. But they park there close to the daycare just because it's more convenient for them to that door. But if it's a problem, I can just make sure they can just park my driveway. I do have space for 5 cars, 6 cars in my driveway. So if it were to ever happen, 6 cars coming in together, I do have the space for it. But it never happens. Never happens ever.
Right. In the space last year, you said there were maybe a handful of occasions where multiple parents all showed up at the same time. They tend to space themselves out.
Usually, if they ever do, it's 2. They all have different work schedules. So,
Able to stagger people coming in?
I'm sorry?
By your own rules, are you able to stagger
Yes.
people coming in?
Yes.
Saying you can drop off a child at 7:30, you at 8, you at 8:30, you
No,
at 9?
I can't do that. But I can tell them to park on my driveway. That I can make a rule.
Have you told them that since you were last here?
No, I didn't make it a rule. I just said it would be better if you did, but I never made it a rule, but I can make it a rule. And I can make either a contract or something and have them sign it. But they can only park on my driveway.
Please feel free.
Good evening, thank you. Just a question. Summertime now, do you still take care of the same amount of children this month that you will in December?
Yes.
So-
So I think in December I'm not sure if I had 4 or 5, but the maximum is 5. But they aged out, so they turned 3 and they have to go to preschool. So right now I only have 3.
I was just wondering if your attendance drops in the summertime because people are on vacation. And then when everyone goes back to school and back to work.
No,
you guys-
not really.
That's all I was asking.
Yeah,
Thank you.
because I have all the kids in my daycare. Because since I work for Cape Cod Child Development, they're voucher kids, so they really have to work. They don't really take vacations. Yeah.
Of course, please, sure.
So you say 3 to 4 cars a day. Now, I heard some people suggest that they were dropping them off at all times of the day. Is that correct?
No. First, the rule of the daycare is the latest they can drop them off is 10 o'clock in the morning. That's the latest. If they go over that, they can't come in. So that's the latest. But usually they never go that late. It's usually from 7 to 9.
7 to 9? Mm-hmm. And
Yep.
and how about pickup?
Pickup, they don't have a time. They can pick up any time. But the kids usually nap until around 3 o'clock, so nobody ever comes when they're sleeping. So it's usually 4 to 5. They never really come before that. If they do, they tell me. It's very rare if they do.
And the ages of these children, you said they age out at 3?
They can stay in my daycare, but at age 3 they go to preschool. And that's a daycare, so when they turn 3, they have the option to go to preschool. They can stay. So usually they just go to preschool, which is better for them.
What's the minimum age of a child?
0. They can be a little, yeah.
And then-
I can only watch 3 under 2, and then
3 at a
3
time,
over 2. Yeah,
Under 2,
yeah.
and up to 5 over 2.
A total of, she can watch a total of 5 because she has one child of her own.
Yeah.
Right.
Yeah.
So I can only watch under the age of 2. I can only watch 3, But they have-
Including your child?
including mine. Yeah, she's 1.
Mean you could only watch 2?
Yep. So I have 2 that's under 2, and my daughter that's under 2, and then I have another one that's 2 years old.
Okay.
Because so the under 2, they have to be, they at least one they have to walk, because in case of a fire, I can only carry 2 kids in my arms to take them out. But we do fire, say everything. There's a lot of rules.
And you were just recently inspected last month, is
Yes.
that what I heard?
There's an annual review.
Yeah, there's an annual.
You should have a copy of her license in the packet.
Yeah.
And just so I'm clear, when they drop off, they're obviously going to work, is that fair to say?
Yes.
And when they pick up, they're just picking up to go home?
Yeah.
And they're only there for a few minutes at a time?
Yep. They don't even come into my house. They just put their kids at the door and leave.
Okay. Thank you, that's all I had, Mr. Chairman.
Mr. Barron.
Yes, something I'd like to clarify from the previous hearing. You do not own the property that you have the daycare.
No, I rent.
You only occupy one part of that building.
Yes.
The driveway is convenient to where you are, but you have no legal right to determine who uses it. Am I correct?
I'm sorry, could you
can't
clarify the
desi-
question?
You normally would not be one that would say, use my driveway.
So it's a duplex, and she rents that side of the house. and
I have
there-
my own driveway.
That driveway is assigned to that side of the house, and it's
Okay.
hers to
Well,
do with.
I
as
wanted to clarify that.
Yes.
Yeah, so I'm the only one that uses my
The-
driveway. They have their own driveway on the other side of the house, so that one is only mine. Nobody
Which
else pays
should
for
be,
it.
I
should
wanted
be
to clarify
reflected in
that.
the pictures that were provided.
Thank you.
I have a couple of questions. Are there ever vehicles parked in that driveway that is used by both streets, parked there on a daily basis?
So,
Your driveway.
yes.
Is there any? What was the
Anything
question?
parked there all day?
So just my car.
Yeah.
The truck that they were talking about is my husband's. He works all day, and it's his boss's truck. They switch it. They go to work, so they have to kind of switch the cars just depending where they work. So that's only after like 6 o'clock.
Can you see the picture I'm holding up?
Yeah.
That was included in the packet your attorney
Yeah, that's my
submitted?
car.
That's your car
Yes.
there? And that's the driveway with the turnaround, the
Yeah.
half round there? Okay. Third round, whatever it is.
Yeah, then the
All right,
truck
and
is
Are there
generally.
children in the neighborhood that do go to school from that neighborhood? Are you aware of it since you live there?
No.
You don't see any children with school buses coming up and down?
Actually, I think I do see kids with the school bus. Yeah, they park. The bus is usually on Wampanoag.
And I want you to help me now. This isn't a program where the kids come and then they get transferred to a school program at some time each day, is it?
No.
All right, so these kids are with you for whatever their parents contract for time. Is
Yeah.
that fair to say?
I believe it's what would you call it? Sort of like it's preschool kind of thing. Right?
Yeah.
Yeah, because it's
Okay.
younger age.
All right, does anybody on the board have, sure, Ms. Britt, of course.
I just have a couple of questions. A few minutes ago, both of you said with a fair amount of certainty that your clients never use Pockanocket. How do you know that?
I just tell them they don't want to use Pockanocket
But that's different from they never use it.
because I see them.
So you visually
Yes.
see they
I see them come in. Yeah,
okay.
they
and-
get their kids and they leave.
Okay, and then when they come on site, you've got the driveway with the 2 entrances.
Mm-hmm.
How does that actually work? You come in one way and go out the other, or? how do you
Yeah, usually they come in. They park like this on
come
Wampanoag.
down? Right, they come down?
So, what was the question? Do they?
The question is, how do they get onto your site and off your site without? parking?
So lately they've been just parking on the side,
Of what?
on the side of the road. So usually when they do that, they just go around the block
So,
to the other
So they do
side.
go around the block,
No, not Pockanocket block, the other block, on the other side.
heading down.
Heading down this way.
so
They do go that way.
to clarify one thing, I think a little confusion is happening. What I said is they don't use the unimproved section of Pockanocket. Pockanocket is improved, and it is visible, I believe, on the pictures, past her driveway. It certainly becomes unimproved, actually approximately at where the next driveway is. But it's improved past her driveway that it accesses on
So they
Pockanocket.
don't go around the block and then go back out the way they came. They actually drive through the neighborhood and go back out the way, and then ultimately end up on South Sea at some point, correct? To get out of the neighborhood?
No, so the block goes back to Wampanoag.
They go back
Goes
out
this
Wampanoag.
way and then go back to Wampanoag.
You turn
Yeah.
and come all the way back?
Yeah.
Okay. All right. Now, you said you could make it a rule or some sort of a requirement that they not use the unimproved part of Pockanocket? You could,
Yeah.
that as your contract or agreement with the people?
I can make my own contract with them, so I can put that in writing and have them sign it. Yeah.
How would you enforce it?
Just have them sign it, I guess. But they never use it already, because I see them come in.
Right.
So that's not, they don't use that road.
And they don't use it at night when they leave?
No, they never use that road.
Because earlier, Mr. Chairman, someone mentioned these new technologies that give you the way to find someplace.
GPS.
Right, something like that. And I will tell you, when you type in your address, it takes you across the unimproved part of Pockanocket. It does not take you up to the,
I agree, but
That's the, so I tell them on their first visit, they come in, they do a visit at my house to see if they're going to want to leave their kids there. And on the first visit, I always tell them, don't use Pockanocket, come through Wampanoag. I make sure I tell them that every time. Because they don't want to use that road anyway, it's a dirt road.
so I think, are there any more questions you have at the moment?
I don't have any more. Is
Okay,
there anything
I think
else you want to say?
only thing I would reiterate is how important service this is to the community to have these types of things, and I would echo what they said in the letter from Cape Cod Child Development, that this really
Sure. We'll consider it your
serves
closing.
them. And the other last thing is a bit of a sort of procedural thing. During the last hearing, some pictures were submitted that featured some of the children attending the daycare. People are not supposed to take pictures of children attending the daycares. It's not allowed, so I would ask that those pictures specifically be destroyed and not be retained in the record.
Once again, that's a wonderful public statement you've made, but we can't enforce that, as I'm sure you know. So, the propriety of taking pictures of any children that aren't your own is entirely suspect to me.
Okay.
A good point, well made. Counsel, Mr. Winter, could you take the mic for a minute? There's been a reference to 40A Section 3 exemptions. Can you help me there, please? Because I'm looking at it, and there's no suggestion that this board can't consider all the appropriate merits of the grant of a special permit merely because of 40A Section 3 is there.
No, you're
Okay.
absolutely correct. I would like to clarify that in one way. This particular sentence in 40A3 is sandwiched between a number of provisions that typically provide, we'll call it a zoning preference, a favorable treatment to certain uses. This particular provision, and I'll let the board know, I double-checked today just to see if a case had come out on this, has not been reviewed by any appellate court, any trial-level court. There isn't any case law on this. This is different than the other provisions. When you talk about the Dover Amendment, talk about educational, religious uses, other kinds of uses that receive preferential treatment. They're all very specific. This one's unique, and I'm not going to give you a legal argument here. It's not appropriate, but since we don't have any case law, I did want to point out that it says it shall be an allowable use unless the town prohibits it.
Or regulates it.
Or regulates it. And that's what this town has chosen to do, regulate it by special permit. You have the criteria. You know it already. I don't need to recite that.
Thank you for clarifying that, because I'm reading it and I'm wondering if I have failed as I've grown older to understand what it says on the back of a LaSalle matchbook cover, you know. Thank you. All right, now we close it to public input, petitioners' input, open it up to board discussions, deliberations, motions, and the like. We've been asked to consider on remand, on a joint agreement for remand, whether or not, essentially, I'm going to characterize what we're being asked to do, whether or not we heard all the evidence we heard last time, or we neglected to hear some evidence either offered by the petitioner and rebuttal by the petitioner, as the case may be, or consider new evidence received this evening. So does anyone want to start the discussion of this? And now I'm going to go out, and I'm going to start with you, Mr. Igo. Do you have anything you want to talk about on this evening?
I think, if I'm not mistaken, we're pretty much taking this de novo, right? As if it never happened? Or?
I don't see it that way. I think we have a very ambiguous order of remand. The order of remand says that the parties got together and they said that there was evidence that we failed to hear, or rebuttal evidence that we failed to receive, and that there were arguments of law that may have not been granted, that the petition may not have been able to offer because of her pro se status. So, but we're treating it sort of like a de novo hearing. So let's treat it like a de novo hearing. So what do you have to say about this petition?
From a legal standpoint, I think, as counsel said, and I've never seen any case law on it, so I presume there's not, but I think we're within our legal rights to regulate it, as the bylaw says. So that's that part I understand. The factual issues, I'm not sure at the previous hearing if we heard or didn't hear. I haven't seen that tape, so I don't know. It was a while since we last met. But you have refreshed my memory relative to what we did talk about. I asked, what we have here essentially is we have a petitioner who has a total of 5 children, no more, because she has her one child. She has children that range in age from very, very young to up to 3 years old. It seems at 3 years old, they leave because they go to preschool. So they're very young. Obviously, they're going to be within your eyesight, I presume, at all times. If she really only has a couple, I feel that she can certainly keep an eye on them.
Speak up, please. I'm having a hard time.
Oh, okay, I get that a lot, sorry. We heard her hours of operation in the morning are typically between 7 and 9, and pickup is 4 to 5. Normally 3 to 4 cars a day. And they come in on Wampanoag Road and they pull into a driveway that appears to be adequate to service those cars. The driveway she uses is exclusive use to her, so she does have the ability to use that driveway. There has been some complaints about the number of cars and cars parked along the sides of the road at various times that are causing congestion. However, when I asked specifically times and dates, I didn't get any specific times and dates and numbers of cars. What I did get from 2 people, they said, well, we don't look out our windows. So I can't really weigh if there is or there isn't congestion. We do allow these, really. We've allowed quite a few of them over the years. Upon further review of this particular petition, I think she meets the criteria for the issuance of a special permit. I don't see any undue nuisance, harm, or congestion to her petition that we wouldn't see with anyone else's. I think it's a short drop-off, short pickup, young children, well-supervised, in a contained area. So I'm just not seeing any reason not to grant this special permit. So I believe that she does meet the criteria for the following reasons that I've spoke of, and I would recommend that the board approve the special permit.
Ms.
Thank you,
Breda.
Mr. Chairman.
To show you the blessings of living in a free society, I must disagree with Mr. Igo. I do think it presents a changing character in the neighborhood, and to the extent that we've heard from the neighbors, they all talked about the congestion, whether it is minimal or maximal, and they're the ones that are being impacted. Whether they look out the window or not, they are being impacted by a business operating in a residential area. It's a difficult melding of, having businesses being introduced into a residential neighborhood. And my sentiment is that it's almost impossible to do without changing the character of a neighborhood and creating congestion. And so, right now, my opinion would be that we continue to support the decision we made earlier. I've been to the neighborhood twice, once before when we heard this, and again just recently, and 2 times recently at different times during the day. It is a lovely residential neighborhood. Kids are playing in the street. There's a group of kids playing basketball. So my opinion has not changed. I still support the decision we made in the previous hearing, Mr. Chairman.
Thank you. Mr. Barron.
In the previous hearing, it was pointed out that there were numerous attempts by town offices to get the proper paperwork and proper request for information from this daycare center. And it was almost, my opposition at that time centered on the fact that it was almost a flaunting of the bylaws of the town. I have not seen or heard anything to change my opinion. So I, too, stand by what we did before.
Okay. And Mr. Nicanello.
Thank you, Mr. Chairman. I really feel bad it's gone this far. She's enrooted now, 34 months. Being a business person, it's up to the person conducting the business to go to the town and find out what you need to do. You're a business person. You're running a business. It's your responsibility. It's nobody else's. No one says, well, you have to do that. You got to find out for yourself. Education comes in all shapes and sizes, and you're now paying the price for education. So I feel, conflicted, because what you do is admirable. You're taking care of the future. Someday those kids will be here making the hard decisions we have to make today, which we shouldn't be making today, because this all could have been avoided 34 months ago. So I don't know how I feel, Mr. Chairman. Thank you.
All right, well, I'm going to tell you how I feel. I feel like I've gotten new information tonight, and I'm struck by a couple of bits that I've gotten. I'm extraordinarily struck by the suggestion made by Ms. Sorbo, who I don't know if anybody else knows, but has been a dedicated servant to children in this Cape Cod area for many, many, many wonderful years. But begging that off her accolades, she cites to something that kind of logically, I think, just flew over my head last time, and that's why we couldn't develop a pattern of a traffic program and put it on a one-year review. Concerning Susan's thoughtful comments, regrettably, this town does not consider the merits of businesses in residential neighborhoods to the extent that we might all on this board like to see. But one thing they have made abundantly clear is that there are 2 types of child care that they do consider in residential and RS 25 and RS 40 zoning districts. Forget any of the business zones. And that is a daycare center being allowed as a matter of right in both residential 25 and 40. And family daycare center, which is what this young woman is petitioned under, being allowed by special permit granted by the Board of Appeals. Businesses, whether we like it or not, are allowed in residential neighborhoods. And so that, as a reason, I don't think is something that this board should consider. But, you know, we're all entitled to our own views of it. I was also struck by, and though he did have a hearing problem, I think he heard me clearly, and I think he responded clearly when I asked him, have you, in the 2 years you have been living there, and the 1 year that this daycare has been in operation, noticed any increase in traffic? And his answer was pretty clearly no. So, I mean, I just see where if you have a plan with a client that, and it's not a plan, it's a mandate to your clientele, that everybody is allowed and entitled to enter that driveway, whether it be from Wampanoag or whether it be from Pocketucket. Thank you. They're allowed. There's nothing that stops them. So whether they enter from one end and go out the other, or the other end and go out the former, it's of no consequence because they're allowed to do that. That's where the curb cuts are. That driveway has been, and that's where it's been for probably long, maybe even long before zoning ever came into being. But so I can see a pattern that you can impose upon your customers that creates no congestion on those streets. Might create some additional traffic, but that's not the question. There's traffic whenever we add a new home in construction on a street. So that alone isn't the question. Does it impose undue congestion? That's the question. And in my mind, I'm going to side with Mr. Igo. I've been persuaded differently than I voted last time, and I think you've done a great job of, particularly Ms. Sorbo, suggesting that there is a resolution to this problem from everybody's standpoint, and that's that you impose a traffic pattern that allows for your people to have a mandate from you that I would want to review. I'm hearing 3 people might not vote for you, and you got to have a 4-to-1 vote in order to pass tonight. But if the vote's 4-to-1 in favor and the special permit should be granted, I'd want to absolutely see a 1-year review, and maybe a year after that review, maybe an annual review going forward for as long as you have that special permit in operation out there, to assure that there are no violations or blocking of other parties who need to access the road to their homes or to leave their homes. That's not fair to those neighbors, but there's no reason it should happen on your site if a good traffic pattern is imposed upon your clients, your customers. So that's my comment. Anybody prepared to want to have more discussion or make a motion, or how do you wish to proceed, ladies and gentlemen on the board? I'm not going to make the motion, so somebody consider it.
Well, Mr. Chairman, when you say something about a traffic pattern, what do you have in mind?
I'm suggesting that they be told that they have to enter into that driveway and not park on the side of the street, and they must exit directly out the other end and immediately go their way. I mean, traffic on that road, merely because you're a resident on that road doesn't mean you own the road. It's a town road. It's a town-accepted road. We all have rights of traveling on and off that road. And if not accepted, at least maintained. So I've just heard the town maintains it, so it's not a private way. So everybody in this town has a right to drive it, whether it's for fun or frivolity, but they don't have a right to block their neighbors, and that's the concern here. So if you impose a pattern where they must enter, I don't care which end you choose. Quite frankly, I don't think it's up to me to tell you that, or up to this board to tell you. But they must enter from one end and exit from the other end, and they are not to park on the street itself as they drop off and pick up children. That eliminates all the problems here. About the daycare and its quality, for all of those people who have comments about this evening, we have no control over that. Do I think it's right that little children should be out there with wire fencing? Hell no. But I'm not in charge of that. I wish it were, because if I were, I'd make it a condition that you put up appropriate, white vinyl fencing to protect your neighbors and to keep those children in there and their fingers not hurt and wire fencing. But that's not our purview. So that's not a condition we can impose.
Counsel, is your client proposed to make a traffic pattern and provide it to us so we can review it?
Would that be acceptable? Would it be acceptable to do what he suggested? Impose a traffic pattern and provide it Absolutely.
Make that a condition of our,
Mr. Chairman, could I make a comment?
Sure, absolutely.
Regarding the suggestion of a traffic plan, I think it's an excellent suggestion, but I think that's only half the discussion. When we have something like that, I think there's a necessary corollary discussion about how do we enforce it. What recourse do the neighbors have if it gets violated? Do they call the police? Do they call the child care center? How do we make sure that if we grant this special permit, and it sounds like a good idea, you've got the circular driveway, things could move fairly quickly, but we're not going to be Panglossian and think that this is going to always be the case.
Well, no, but
How would we
but
enforce
as I heard somebody come up to the lectern and say, it's extraordinary for what happens here between May and August. He said August. I think it's extraordinary what happens here on the Cape between May and October 10. That people come down, they visit, they come down in hordes, they park everywhere. I know I've got parking for 7 cars at my home, and sometimes I have 10 there. So where do they go? Up to my neighbors and cheat, or up to the road and park. Neighbors very gracious, but those things happen. So even neighbors who are having guests down are parking in the street, impeding traffic for other people, such as this young lady that would wish to use it. So, what's good for the goose has got to be good for the gander. That's why I suggested a 1-year review. If it would be more appropriate to consider a 6-month review, and then put it out for the 1-year anniversary of this, and then maybe a 1-year review after that. It's much like and in terms of policing, Susan, I hear you loud and clear, but I expect that everybody I've heard from in here tonight has been an honest presenter of facts. And if we remember over to the sound issue at the golf course, we had to take people and weigh what they had to tell us. And was there a reporting mechanism? Sure. They got on the phone, they called the police, and they said, it's too loud. The police went out and investigated. If somebody's impeding the traffic, I don't know, go out and take a picture, date it, present it to us next time we review it. But, I do agree that there is a value to this community, and a pretty great value, that little children have a place to be cared for.
Absolutely.
This is where you've chosen to care for them. It truly, I agree with Mr. Barron, please know, I think it's sinful when anybody comes in here after the fact and gets relief. But that in and of itself is yesterday's news. And then you were directed here, and now you're trying to do the right thing. So, in my mind, we can grant this relief, protect the neighbors as they should be, by demanding a traffic pattern. And guess what? It's up to you to enforce. And if you fail, I guarantee you every neighbor that you've heard from in here to this evening is going to tell us that. And they're going to tell it loud and vocal the next time we ask to review it, if we get that far tonight. And that will weigh on whether or not that permit should continue, because it's going to be a very strongly enforced condition, if in fact this goes through this evening. So, I mean, I'm just telling you, I'm going to change my vote. So, I think I voted against it.
yes.
I don't even remember now.
Mr. Chairman, could I'll just start the ball rolling.
Sure.
I'd like to make a motion that we approve the special permit as requested with the following conditions. That the clients of the petitioner enter and exit from her driveway. And I would say that if they're going to pull in, they got to back out onto Wampanoag Road. I don't know if you want to do some circular pattern where they drive around the circle, but it appears to me by looking at these photographs, and I happen to know the road quite well, that you can just pull in your driveway and drop off. I would also suggest that we have a 1-year review on this, because that's historically how we review these. I don't think we need a 6-month review on this particular matter. Again, we've had a number of these, and we generally set them up for 1-year reviews. I don't know if there's any other conditions. Those are really the only two that we talked about.
So your traffic pattern would just be in the driveway?
Well,
It's up to them
Pockanocket
to
Road,
provide one to us.
well, I mean, you can do that if you'd like. You can print one out and show us how they're going to come in and come out. if you want to do something circular. But as Steve said, Wampanoag is, and I believe Packanacket are public ways, so I don't think we have the jurisdiction to regulate what road they come in and what road they can't come in. I'm quite familiar with Packanacket Road as well, the unimproved part, and although it may be graded right now, probably in 6 months from now, it's going to be the usual potholes and constant mud puddles, and it's not really a pleasurable road to drive down.
Yeah.
So I don't necessarily think it's good for her business. So I think after her customers understand which way is the best way to come in, they're going to definitely come in on Wampanoag. But those are the only two conditions I think that I would offer in my motion, Mr. Chairman.
Okay, is there a second to that motion?
I'll second, Mr. Chairman.
And Mr. Nicanello seconds Mr. Igo's motion with the two stated conditions. Does the board care to have any discussion before moving along to a vote?
I would say that if in fact there are those that are still going to vote against this particular petition, that they understand that and in order for us to deny it, we need specific findings as to the reason why it's going to be denied, or it's going to go right back to the land court again. And I have a feeling that it's, I don't know if it'll be remanded with instruction or if we will be overturned or what have you, but I would just suggest that to the board.
And with that, my second would be on the conditions you make and to give it a chance and to see what happens. And the one-year review could, determine maybe the neighbors will work and there will be some harmony for the kids.
And Susan, relative to your question, how do you enforce it? There is an enforcement mechanism, and Mr. Grills is in the audience tonight, and should anybody be aggrieved or feel there's a violation of this petition or a special permit if it issued, then they would contact him directly, and he would go out and do an inspection as to whether there was or was not a violation. So there is a remedy for that.
Mr. Chairman, with the conditions of the petition, of the motion, I could accept it for the particularly the one-year review.
I think that it's important for us to say, because there are people that may be aggrieved either way we vote this evening, that in voting for this, for those people that vote in favor of this petition this evening, they are essentially voting with a statement that the grant of this relief will result in no substantial harm to the established or future character of the neighborhood or town, nor will it create any undue hazard, nuisance, nor congestion. So keep that in mind, okay, as you weigh your vote. Because that's what a vote in favor would say. A vote against would say that, in fact, there is undue hazard, nuisance, or congestion, or that it's impacting the neighborhood or town's character. So there is a motion made by Mr. Igo, seconded by Mr. Nicanello, to grant the special permit upon the petitioner requiring all of her clients to enter into an understanding that they must enter into her driveway in order to drop off and pick up children, and that they must exit her driveway in appropriate fashion. Drop off the children and leave the premises. They are not to park on the streets. And number two, that there would be a one-year review of this petition to determine whether or not, in everybody's mindset, it's been working, and if not, what to do about it at that point. So on that motion, unless anybody cares to have any more discussion, all those in favor, please indicate by saying aye. Aye.
Aye.
Those opposed?
Nay.
And so Ms. Britta is the only nay. Okay.
Correct.
All right, so with that petition passes, and as you understand, I'm sure you do, Counsel, but for the purpose of everyone else, a decision will be drafted or will be filed with the town clerk's office. 20 days must elapse before that decision is considered final. If there be no appeal, you would then take that special permit, you would file it with the Board of, with the Barnstable Registry of Deeds, and return proof of recordation back to our board secretary. Okay? Thank you very much. Have a nice night. We'll now go to the next petition. Representing on that, please come forward. That is 5809 Susan Snyder of 12 Race Road, West Yarmouth, Massachusetts. Property located in a zoning district R25. Our applicant this evening is Wait just a minute for everybody to peacefully clear. Okay, so now we can move along. So this is petition 48. I'm going to ask you to be quiet, please. Okay, we take this pretty seriously. We're all up here trying to do our job. It's petition 4809, that of Susan Snyder, 12 Race Road, West Yarmouth, Mass. Property located in a zoning district R25. Our applicant seeks a variance from bylaw 202.5, number 48, for the I guess they mean use table number 48, I guess, for the creation of a two-family dwelling without required minimum lot size. And will you identify yourself for us, please?
Yes. Good evening, Mr. Chairman. Susan Snyder speaking.
Okay.
Property in question.
You need to pull that microphone right in front of you, please.
Thank you, Mark.
Thank you.
Property in question is located at 12 Race Road in West Yarmouth. Can you hear me okay? Okie doke.
We can, thank you.
You're welcome. I should be in bed now.
We all should.
Right.
Go right ahead, please. We have another two petitions after you, so what do you want to tell us about
I'll be very quick and precise, sir.
Please.
I'm here basically, like it indicated, to change the zoning from single to a double-family dwelling and relieve the zoning requirement of the lot size. And specifically, that's it.
All right. And so you come to us as a result of some enforcement acts? Is that how you get here? Enforcement action by the town?
Pertaining to what, sir?
Pursuant to your use of the property as being in non-compliance with zoning bylaws.
Well, that's questionable. Originally...
No, I'm not asking if it's questionable. I'm asking, is that how you find yourself here tonight?
Yes, sir, yes.
All right. And as I understand it, you received some enforcement from the town of Yarmouth, specifically building code violations and that health code violations, zoning bylaw violations. And as a result of those violations, matters were brought before the, it appears to be Barnstable Superior Court, in docket number 1872 CV 254. For those people that are at home wondering what the hell I just referred to, it's number 254, complaint filed with the Barnstable Superior Court for 2018. And as a result of those proceedings, before that went to final judgment, the judge apparently indicated that you should come and try and get some relief from this board. Is that right?
Correct, sir.
All right.
Yes, Mr.
So now we know how we're all here.
Okay.
All right. Now, is there anything else you want to tell us about this? Because we have a petition in front of us that says that you, Susan, want to change the existing, to downstairs change the downstairs apartment. And that you want to change it by making it a allowed second family unit. Is that
correct, sir?
What you're trying to say?
It doesn't have adequate frontage in the front, but I would, regardless, I would like to continue and apply for a variance to change the zoning.
All right. Very good.
Please.
Very good. So,
Mr. Chairman, my understanding of this, just so we're clear on this, is I believe the petitioner is seeking to create a two-family dwelling on a single-family lot without the requisite square footage. And so that's why she's seeking a variance here tonight.
Okay. I don't know. I'm reading verbatim what's on the petition, and we don't get to make these petitions up. I'm merely trying to help you along to explain what the heck you're looking for.
I think I read that somewhere. Mr. Grills may have want to weigh in on that for clarification.
It's always so much fun when you're here, Mr. Grills.
Never a dull moment. Good evening, Mr. Chairman, members of the board. Number 48 refers to the footnotes, which tells you that you need to have double the minimum lot size for a two-family dwelling.
Could you repeat that, Matt? Say that again, please.
Number 48 refers to the footnotes that requires that you have double the lot size for a for a two-family dwelling.
So in this case, Mark, while we have you there, so we're in an R25 zone, correct?
Correct.
In order to create a two-family home on this particular lot, she'd need a minimum of 50,000 square feet?
Correct.
Okay, thank you. And how many does she have right now? Does she have like... Do we have... What do we have right now for square feet?
Approximately 6,098 square feet.
6,000.
6,098, correct.
Where? Okay.
On here.
All right.
Okay.
Well, let's keep in a usual rhythm here that we usually like to try to have. Ms. Britta, do you have any questions of petitioner?
Just a couple, and these are sort of practical questions.
Well, you don't have to leave, Mark. I think you're going to be questions for you.
There's a lot that would have to be done to the site, like a new septic system and
Correct.
just to start with. Have you priced those out? I mean, I haven't done anything like this in ages, so I'm interested. How much would a new septic system cost?
Well, that was a very good question. I have an answer for you, actually.
Okay.
And I'm in the process of applying for a government loan, septic system, 3-bedroom.
Mm-hmm.
And the site work has been paid for by Wells Fargo Bank. My engineer submitted a proposal to Barnstable loan application for a 3-bedroom septic. This meeting will determine, they're waiting for my application for my tenants to come in for upstairs, so I could submit the application to verification of income to qualify for the government loan program so that I can get going on the septic. And that's basically my last hurdle. So I'm working on it, yes, thank you.
That's it, Mr. Chairman.
Is that it? Mr. Igo, did you have any other questions?
Yes. Ma'am, have you've obviously looked at the town bylaw, correct, with Mark?
Correct.
You guys have reviewed it.
Yes, I talked to Mark.
And we don't have enough square footage in the size of the lot.
Right.
Okay, so you're seeking a variance. How is it that you believe that we could grant you a variance?
Well, one, it's your job.
Okay.
And I filled out the paperwork, submitted the application, talked to Sandy, and the property in question is actually on 2 different streets. See,
But you understand you need a minimum of 50,000 square feet for the lot size,
correct.
and you only have 6,000 square feet. So you have like a little more than 10% of what you need to
Correct.
get a two-family dwelling on that lot. So, and the criteria, it seems, of a variance, you're not meeting it. So I want to hear from you how you feel that this board can grant you that relief.
Okay, sir. Mr. Io.
I go.
I go.
Yeah.
Well, sir, pertaining to your question, because I've been living there 10 consecutive years in a row. 10 years in a row, and I've been renting the upstairs. I'm trying to determine 10 years later, I mean, that's moving kind of slow. Like, I mean, you know, understand where I'm coming from? Like, I've been there for 10 years. I've had numerous permits. I pulled building permits. I pulled numerous permits. I couldn't tell you how many inspections, and I've always complied with the building inspectors and the town departments extensively whenever possible. Nowhere did they intervene ever across the board and indicate that I could not live there. And my attorney from Nantucket, PC attorney Paul Jensen, when he came here to represent me, he met with the town officials. They were different. These are new board members. And there was no problem. He said, Susan, go ahead, just put a safety window in, and you can live there. And furthermore, there was a family living downstairs already. It was designed, excuse me, Sandy, do you have the pictures I submitted?
No.
The pictures, it had a kitchen.
You got a set of pictures we're passing.
Okay, there was a kitchen, bathroom,
Clark
and
is
set
not
up as
getting
apartment.
invested in the meeting.
Excuse me?
I said Ms. Clark is not going to participate in the meeting other than in her role.
Okay, thank you, sir.
Yep.
But you looked at the pictures.
They're looking at them now. You
Okay,
gave us one
okay.
set.
Thank you, sir.
I think I'm all finished, Steve.
Yeah, you'll get him as soon as he's done. Yeah. Go ahead, please.
I'm done for now,
Okay.
thank you.
Thank you. Thank you. Mr. Nicanello, any questions? Oh, thank you. Very nice interior. This is of your apartment?
Correct.
You keep
Yes,
it
it
very
is.
nice
sir.
and neat.
Thank
That's very
you. I
nice.
put a lot of time and money into it.
I bet.
$260,000 restoration. And my dear friend, Carol, the property management, she's helped me and Pete immensely. They paid for the entire renovation of both floors of the house. So that's why it looks so good. It's
Good.
Carol.
All right. Mr. Nicanello.
Yes, thank you, Mr. Chairman. Well, thanks for being in our town for 10 years. We appreciate it very much.
Thank you. I appreciate meeting you, sir.
Yeah. So what is your vision for the future, the next 10 years of your property?
Correct. Well, I'll be turning 63, sir, right? And my intentions are to get back up and running, submit my septic application, get my 3-bedroom septic, put the house on the market. And that's it. It's too much for me. I can't mow the lawn. I can't do lawns. I'm on 2 different streets. The maintenance is just, it's getting too much. It goes on and on. So I do all the work on the house, everything. Those are my intentions. Eventually, I can't, at 63, I mean, down the road, there isn't much more to do. I'm done. I sell it and go,
All right.
you know?
Yep. Okay, so was any of your intentions is to bring all these violations up to snuff so they're not violating anymore?
Correct.
Okay.
That's why I'm here. I'm trying to comply and work with Brad and Mark, and they're helping me as far as the process goes, like what needs to be done and, the process of doing it and everything else, and I'm trying to comply with it. Unfortunately, it costs money, and so I'm just working along those lines. Like I indicated, I already contacted the engineer and he submitted the proposal.
Now, how long has that other family been living there, may I ask?
Forever.
Okay, so you bought it with the assumption that it was all set, or?
That's correct.
You just 1 bedroom and the people were downstairs and?
They were living downstairs. People lived upstairs forever. And when I bought it, I thought, wow. Everybody said, Susan, this is perfect. I mean, it needed extensive work, and I was willing, and thank God I had these skills and capabilities to bring it to fruition, which I did, and to the best of my ability. But regardless of that, my intentions, in 10 years I've been living there. 10 years. So if in the event it was brought to my attention to change it, I would have complied. I would have went right to the town building right away without hesitant, and I would have complied with whatever wishes they deemed necessary at the time.
Understandable. So when you bought the property 10 years ago and your deed said it was a single-family house, you just didn't know what that meant, or? I was just asking.
I just bought a house.
Right, I understand.
Correct.
Okay.
Yes.
All right, thank you, Mr. Chairman, that's all I have.
Thank you. Mr. Barron.
Well, following up on that last question, you bought the house understanding that it was a single-family home?
Yes, Mr. Barron, I did.
Were there other occupants in the building?
Correct, sir.
So how did it become a single-family home? Are they related to you?
Well, obviously, when I moved in, they moved out of the house. They weren't relatives. I'm not from this area. I just bought the house, and it had a house upstairs and downstairs.
At the present time, are you the only occupant of the house? Or are there other occupants on another floor?
When I bought it, there was nobody. Yes, I've rented it extensively all along. Correct, yes.
So you've been renting to a second party.
Correct.
You are party one. You've been
yes,
renting
sir.
to others.
Yes.
Have you gone through the town to have that rent recorded as a rental property?
Yes, I paid for a rental license. Precisely, I did. Yes.
How many years have you done that?
Since day one, about 9-10 years. Well, after I cleaned it up a little, to the point where I was able to rent it to actually have an inspection. It took about a year or two because the place was horrendous. And I cleaned it extensively. I made it look beautiful. And then I got a rental license and continued to work on the property.
If you did get a rental license or permission from the town, why was that not in your submission? Why was that not in your packet?
I do not know.
Okay.
Excuse me, Mr. Barron. One time, I went to Housing Association of Cape Cod, and I had inspection. It passed inspection. Yes. So mainly, these are different board members. I was working with Brian Easlip, the Board of Health, and the building inspector. What's his name? But anyway, it was a different board. So I've worked with them, and I think they've been here for 2-3 years. I'm not sure. So that's who I obtained my license from. I paid the money, I've had the house inspected, and I've been renting it. However, I have had trouble, like bad tenants. I do admit that. I do see where I had some very bad tenants, and I corrected the situation. I have a property management now, and he owns 38 rental houses, so he's helped me get good tenants.
What?
Everybody's going to get a chance to talk, okay? What we're not going to do is make it a free-for-all, so keep your
A
comments
witch
to
hunt.
yourselves.
That's what it is, a witch hunt.
Well, You know, that's not helping anything, okay?
No, it's not. I'm sorry.
If you feel it's a witch hunt, it doesn't help us by telling us that. Let's move on to
Correct.
the merits of the petition.
Okay, I apologize.
Do you have anything else?
Not at this time.
Okay.
All right. You know, I want to know, do you occupy the property?
I do, sir, yes.
Where do
Again,
you occupy?
I live downstairs. I've been living there for 10 years.
Basement apartment?
Yes, correct, sir.
How many bedrooms are down there?
One.
And how many are on the first main floor?
One.
Okay, so 2 bedrooms in full.
Correct.
And you occupy that property year-round?
Yes, I do.
I gotta go to the ladies' room. I'll be right back.
And you talked about lots of times that you've gone before the town and you've asked for a building permits, and I see that when you bought the property in February of 2010, you next acted to pull a building permit in November of 2010 for some type of alterations inside. 5 years later, or just under 5 years, you installed insulation. And then in 2018, you pulled the permit to put some windows in. Is there any other time that you've had a building permit that you've pulled for this property?
Several.
Well, they're not noted here. Perhaps
They weren't here extensively.
Okay.
Well,
And so
Mr.
were there
Chairman.
inspections done on each occasion?
Of course.
And were there any municipal employees of the town of Yarmouth that told you that you were in violation of our zoning bylaws?
No.
You haven't received any violations?
I don't believe so.
Have you received notices that you needed to pay fines for violations of our town bylaws?
Fines?
Yeah.
Not that I'm aware. I didn't pay
Okay.
no fine.
All right.
Not that maybe I did. I
Well, I'm
don't
reading
know.
here that where the property's been in violation for many times. The history of complaints, I'm now going to read in the Amy Von Hone memorandum dated July 10. And I'll go through it and ask for your comment.
Okay.
History of complaints and violations regarding unregistered rental use of the property dating back to the 1980s. You're unaware of those?
Right.
Okay. The most recent inspection by the health department, as witnessed in the past, revealed the first floor and the basement level are being used as separate living quarters by the owner and tenants. Past inspections have witnessed illegal use of attic space for sleeping quarters. Have people been sleeping in the attic?
No.
Okay. And is there a business of small engine repair going on in the garage?
My friend Tom, the retired police officer.
I don't care who he is. Is there a business of small
It's
engine
not a
repair?
business. He has 2 trailers out there, and he stores some lawnmowers. He's very elderly man. He couldn't run a business. He's had a stroke. The guy can't even walk. It's no business. I mean,
Okay. And due to a lack of record, did they come and inspect your septic system and the health department? Did they come and inspect your premises and tell you that you were in violation? Well, we're going to
yes.
hear from them. No, we'll hear.
Well, no, I'm trying to figure this all out because
I mean, it's only been 10 years, so.
the septic, that when I bought it, the town said it never failed, it never passed.
I see.
They couldn't even find it. I sent
That's
the
not my
town
question,
a
is it?
map.
But that's not my question, if we can stick with my question. Did the town come out and inspect the property? Board of Health, did they come out and inform you that they witnessed that there were violations of the town ordinances because you had people living on the first floor, in the basement, and in the attic, and they were 3 separate groups of people? They come out and tell you something like that you were in violation?
10 years of it.
10 years they've been telling you
But
that.
they never told me to come here and change the variance.
They don't have to tell you, ma'am.
Well, then why am I here now? They told me now.
They don't tell you how to go about it. It's your job to find out how to go about it legally.
Well, there was never in question until I got this, and then I realized I had
And
to
it
change the
appears that the current assessment is for a 1-bedroom, 1 housing unit only. And yet you're running a business of, you're telling us, of rentals there. And meanwhile, this property's been assessed over the years as a 1-bedroom, single-family property. You understand the significance of that? Your taxes would have been substantially higher had there been two family units there?
Well, why didn't the town, when I got my license, why didn't they go up on the taxes?
Well, I'm
and
really
send
interested in
me,
this license, but I don't see a history of it here. But maybe
never sent me a
maybe
bill
Mr.
saying
Grillis
they
can
went
tell
up.
us about it, or the building department can tell
That's
us about
kind
it.
of lackadaisical in my question, really.
They're lackadaisical.
I mean, if
All
you're
right.
going to go up on the taxes, why wait 10 years? I mean,
me?
really?
Sure. Oh, yeah. And I also see that it's 6,800 square feet, 6,098 square feet.
Well,
All right, so I've read in what Amy Van Hoen has had to say, and we're going to let you comment in just a minute.
Okay.
We also have a memorandum from Town Council who's here, and two of you rather from Mark Grillis, Building Commissioner. Is Mark still here?
yeah.
Mark, do you want me to go through your memorandum, or do you just want to tell us all about this wonderful history of this property?
You can read away, sir.
So he indicates that there are code violations existing as of May 21, 2019 as follows. Building code violations, second dwelling in unit and basement constructed without required building material and associated plumbing and electrical permits. Basement egress door, which had a building permit issued, must be exterior grade, does not meet the energy code standard, and code required fire separation between garage and dwelling non-existent. That's good. That's him to enforce it. Now we come to us. He tells us that there's a second dwelling unit without proper approvals from Zoning Board of Appeals and a small engine repair business operating from the garage. Residentially, the zoned business use not allowed without special relief from ZBA. And is this in the APD, do you know, Mark? Is this in the APD?
I'm certain, sir.
Huh?
I'm not certain.
Oh.
Look it up.
Okay. So I'm not going to deal with the health code violations. I've just read that. But I do want to note that under an additional comment, house is assessed as a one-bedroom, and any expansion over one bedroom will require the septic system to be upgraded per engineered septic plan. This department has no record drawing. You said you had your engineers draw a drawing,
Correct.
right? Have you submitted that to Mr. Grillis yet? He's sitting right behind you.
Well, he's aware of that I was in the process, correct, Mark?
Have you submitted it to him is the question.
Well, no, you haven't, but you will. Getting back to the septic issue,
No,
that's for,
I only asked, have you submitted the plan to him?
I just said no, but that's for a two-bedroom.
Okay.
It's not for one, it's for a two-bedroom, and it's 1,000-gallon capacity.
1,000-gallon septic tank with cesspool. That's what this system currently
Yes,
is.
it is, correct. Exactly.
Okay. All right, I've got no further questions. Mr. Grillis, would you come up, please, and help us a bit here? When was the first time you submitted, when was the first time this property was the subject of a violation, sir?
Prior to my existence with the town of Yarmouth, which is 7 years ago.
7 years ago?
Well, before then.
Okay, but at least the 7 years you've been here.
Yes, sir.
And how many violations have you issued from the building department?
At least four notifications.
And have those, in fact, identified the fact that zoning relief was needed here?
I believe so, yes.
Tell us when the first such violation notice was submitted.
Do not know the exact date.
All right, perhaps Mr. Winter will be able to tell us, and then when he's done, he'll be able to get on the road and go home. He starts a trial tomorrow morning at 8:30, the poor man. So, is there anything else beyond your memorandum you'd like to tell us?
No, I think that pretty much covers it. Just that this has been remanded from the courts to come back here because we ended up bringing it to Superior Court to get these
Superior
issues
Court for
resolved.
what, Mr. Grillis?
To get these issues resolved, we've been for years and years and years of trying. We went through town council, who brought this to Superior Court.
Gotcha.
I think I think, if I may, I think it's been remanded here, and I'll let town council speak, but I think it's remanded here because she's not exhausted her administrative remedies coming to this board before she can then appeal to the Superior Court.
Well, I want to clarify, the Superior Court did not indicate that it should come before this board on remand.
Oh, okay.
What they suggested, am I correct, counsel? That what they suggested was before the Superior Court could enter final judgment, they wanted to give this petitioner the opportunity to petition for relief. Is that how this all gets here? Please feel.
Mr. Chairman. So I know there's been a great deal of discussion about the enforcement component of this case, the compliance component of this case. Just to clarify something you already know, that part's before the Barnstable Superior Court. There's no appeal pending before this board on the zoning component. So I know it's relevant to the discussion of the variance that's before you, but that's being decided by the court right now. And the reason why it's before you is because the court issued a preliminary order, and we've put motions before the court to wrap this case up. And the court is now deciding, and it's held 2 hearings so far. There's a 3rd hearing scheduled for August 8th. And what the court is deciding is whether or not to issue an order for compliance and what that order should consist of. So before the court makes that determination, the court needs to know what is the baseline Ms. Snyder needs to comply with. Now, up till this point, considering the 9-year history of enforcement efforts by the town, we've suggested to the court that the denominator, the baseline, is that it's a single-family home because that's what it's zoned for, that's what it's allowed for, and that's been the baseline all along. But the court, out of an abundance of caution, suggested that rather than issue an order that's contingent upon something that may or may not happen in the future, we should know whether or not the town would allow a variance which would lawfully make this property a 2-family. And therefore, what she would have to comply with would be different. So the outcome of this proceeding will determine what it is she needs to comply with. So we don't need to determine what the violations are or the scope of them or what has or has not been done within this context. But what the board does need to decide is what is going to be the zoning for this property, single or 2-family. And the standard that this board has to apply is the variance standard, which, as you know, is extraordinary relief, and there are very particular criteria that the board would need to consider. So the court did not remand it. The court did not suggest an outcome. The court did not suggest a preference. The court simply wanted the boxes to be checked off before final judgment issued so that final judgment could be complete.
I just want to say to the people at home that think that the decisions of this board may result in a lot of litigation are wrong. The last one we just had before this was something that was probably the first in ages, isn't it? Years. So we're not keeping town council very busy, and I'm glad to see we didn't do anything that prompted this matter to go to court. So does anyone in our audience care to speak in favor of this petition? Boy, that hand went up fast. In favor of the petition, please come to the microphone and be heard. Seeing none, does anyone care to speak in opposition to the petition? Please come to the microphone. One at a time. Try to keep your comments brief, okay? Only because we're going to call this over.
4 Race Road, West Yarmouth, and I am against this.
And for what reasons? Why don't you tell us?
The lot is too small, and I looked at what they did with my 10,000 square foot lot, and they made me go to the Board of Appeals to replace a shed that I already had. I have much more room than she does.
Gotcha.
I don't think it's a safe. We've had issues with this, with rentals there.
Fair enough.
I know the history of the house, at least from 1973. The house was finally abandoned by the previous owner. He left it, walked away, went down south. The house was in foreclosure. And it's been very entertaining for the last several years in our neighborhood.
Thank you very much.
You're welcome.
Thank you.
And who else would like to speak in opposition? Can I have another show of hands? Who wants to speak? One more person. Okay, thank you. Please, would you identify who you are? Tell us where you live.
Yeah, my name is Cindy Harvey, and I live at 47 Mill Pond Road. It's about 3 houses away from her. There's a corner right there, so even though I'm 3 houses away, as a crow flies, it's about 1 lot away from there. I've lived in that house for 4 years now, and for 4 years she has rented to various people, and there has been nothing but screaming, fighting, yelling, plenty of threats. I can't even go into how many times the police have been at that house. There is no way that there should be anybody allowed to rent in that home. I don't think she can get along with anybody. She can't get along with any of the neighbors. And as far as her choices of people that she chooses to live
not
there,
gonna go-
okay, well, I'm just saying the problems that have been there in the past 4 years, since she was no longer, since the last people were forced to move out of there, I got to tell you, it has been the quietest our neighborhood has been in the 4 years I've lived there. It's just, it would be really, really bad to have any more people move into that house. It just wouldn't be a good idea for anybody, not
you
for the
very much.
town or for them.
Thank you.
They all rent, and I live
Did you,
downstairs.
did you want to ask her a question? Did you, excuse me. We're not going to do this. So did you have any questions you wanted to ask of that young lady before she leaves?
Well, I just said everybody in the neighborhood rents.
You're going to be able to comment on all you want.
That's all,
after people Okay, whatever you want to comment. No, you've already been up once. We
Right,
get one
okay.
shot here tonight.
Thank you.
No, not you, ma'am. Person behind you. Yes, sir. What do you have to say?
All right, my name's Colin West. I live at 18 Race Road, which is directly next to 12 Race Road. And I'm completely against it. Not to beat a dead horse, but the police have been there multiple times in the course of the 2 years I've lived there. The town, I know, has been there multiple times. I am very curious if there actually is a rental license issued to that house, because there's been multiple renters. It's never worked out. Yeah, that's where I stand on that.
Okay.
And as far as something else, working in the trades myself, I am really curious as to this whole funding plan for this project. I do know septic systems cost quite a bit of money. Separate electric meters, separate water meters, all that kind of stuff to get this up to snuff. So, she's talking about government grants. Whose money is that really, who's really paying for it? So, yeah.
Okay.
Thank you.
Do you have any questions of him? No. Next person,
They
please.
rent, and
No, we're going to go in an order, though. See, we're going to allow everybody that wants to speak in opposition.
Right,
to come up.
I apprate it, thank you.
Okay,
I
and
don't
then you're
know
going to be
these
able to
people.
offer all the comments you want,
Right.
within reason.
And do I get to vocalize my opinion on each and every one of them?
No, we're not going to make this a public
Simultaneously.
commentary about personalities.
Okay, thank you, sir. Okay, thank you.
Your name, please, and where
My
do you
name
live?
is Marie Dipple. I live at 14 Evergreen Road. I have lived there for 16 years this month. That house has been a disaster, a total eyesore. And the people, her choice of people that she rents to.
Well, again,
is
I don't want to get into the
absolutely
choice
incredible.
of people. Okay,
we'll get off that. I would like to know who Susan says rents. I own my home. The rest of you that all own your homes, show of hands.
Oh, no, wait a minute.
Oh, I'm sorry. I didn't mean to
I
take.
get to conduct this.
You do. I'm sorry.
Okay.
I am sorry, Mr.
And it's
Chairman.
not a game of who raises
No,
the hand.
I'm sorry.
So
I am
let's keep
so
it on
sorry.
the point of what we're here for this evening,
Right.
which is to comment as an abutter as to whether or not you are in favor or against the petition
I am
that's in front
against
of us,
it. I am
and for
against
the merits of the petition, not the personalities involved. Okay? I'm not gonna
Because
get into
of
that.
the size of the lot is why I'm against
Now
it.
that's a thoughtful comment. See?
Thank you.
Thank you.
All right. Who's next? Okay, seeing none, then we close it to public comment and offer to you the ability to make any response you'd like to make to what we've just heard keeping it out of the realm of personality conflicts between you and your neighbors. I'm not interested in that.
Okay,
Okay?
fine.
So what would you like to tell us in response to what they've had to say, if anything?
I would just like to indicate, I don't know any of those people.
Okay.
Never really seen them. They don't work. I live on a different street in the back. Yes, the house was a bank foreclosure.
So you're not occupying this.
Pardon me?
You're not occupying this.
She's saying she's facing Town Brook and doesn't.
Right.
Oh, I see what I got.
I was chased and threatened out there.
I
That's
got
a
you.
bad area, sir. You know, the neighbor, I'm coming home, he's up there on the stretcher, dead. My neighbor, they stabbed her son 7 times, drugs in the area, a lot of cars going, fast cars in and out, traffic. I live in the back.
I see.
I don't want to see it. I go up, collect my mail, that's it. I don't know their name. I don't associate with anybody.
Again, though, but let's see if we can't stay focused on the permit that you request.
That's what I'm doing. I
The
live
variance that you
downstairs,
request.
and it's a hostile environment for me. Coming from Nantucket Island, you know, I'm related to everybody over there, and
All right.
I'm an outcast. I don't know anybody in the area.
Is there anything else you want to tell us about the permit? The permit. Your petition, rather. Your petition.
I have absolutely
Anything
no,
else about the merits of the petition, not the neighbors?
absolutely no comment whatsoever. Thank you for asking.
Okay.
Thank you.
Now, we close it to everybody's input other than the board's discussion and deliberations, okay?
Yes.
All right. Yes, Mr. Igo, I see your hands up there.
I just want to be clear as to what we have in front of us tonight. I'm reading the legal
This
notice.
is one of the strangest meetings I've ever attended. In 20 years of serving this town.
Right.
I want to tell you, Mr. Grillis will verify that. Mr. Igo will, too.
It's always an adventure.
Please, go ahead.
Okay. Well, according to the legal notice, the applicant is seeking a variance for the creation of a 2-family dwelling without the required minimum lot size.
Yeah, that's the focus.
That's the focus. Now, she has a lot that is 6,098 square feet. She's in an R25 zoning district. The minimum lot size is 25,000 square feet. If she wants to create if she wants to have a 2-family unit there, she needs a minimum lot size of 50,000 square feet. She does not have that. In order for her to get a grant of a variance, she has to show a hardship. That hardship has to be owing to circumstances related to soil conditions, shape, or topography of such land or structures, and especially affecting such land or structures, but not affecting generally the zoning district in which it is located. Desirable relief may be granted without either substantial detriment to the public good or nullifying or substantially derogating from the intent or purpose of the bylaw. I do not believe that she meets the criteria. I don't see anything relative to soil conditions, shape, or topography. It is exclusively related to the fact that she does not have enough square footage on her lot to qualify for this variance. So there is no hardship here.
I got to chime in and say I think it would be a substantial derogation of the nature and intent of the bylaw for the very purpose that these lot sizes for 2-family homes, there was a thought behind it.
Yes.
And the thought behind it would be that there would be sufficient room and as well permeability of the land to the water table for these 2-family dwellings on a single lot.
And that was absolutely, I believe, the purpose and intent of the people at town meeting when they increased the lot sizes from what was once probably approved for that lot size, when they increased it to R25. But she clearly does not have enough lot size here to meet the criteria for the consideration of a variance. And I would submit to the board that, or suggest to the board, should I say, that we should deny this petition. Thank you, Mr. Chairman.
Okay. Does anybody care to have any discussion beyond that of Mr. Igo's comments, or can we perhaps at this point consider a motion by someone and move it along? Does anyone want to chime in and beyond Sean's comments?
No.
Okay. I think we're all ready for a motion then. Does someone want to make a motion?
I'd like to make a motion that we deny the request for variance, Mr. Chairman.
Is there a second to that motion? Mr. Nicanello seconds? On that motion made by Mr. Igo, seconded by Mr. Nicanello to deny the requested relief, that is, that of a variance, and for the reasons so stated, so eloquently by Mr. Igo. Does the board care to have any discussion before moving it along to a vote? Hearing none, all those in favor, please indicate by saying aye. Aye. That carries unanimously. That means that the requested relief is denied.
Great. But it's still a single-family dwelling?
Yes.
Okay, because my renters will be coming in.
Okay.
They happen to be black, and I don't want to upset the neighbors, because I know they're high,
Okay,
they
well,
don't
I'll
like
write a
that.
decision. I'll write a decision, and that decision gets filed with the town clerk's office.
Great.
And you, as the aggrieved party, can have 20 days to appeal from that
I'm not
decision.
going to appeal it, because I
entirely up
would
to you.
like to get out of Yarmouth anyway.
Okay.
Those are my intended
Okay, I'm just
purposes.
telling you your rights, though, okay? And we
But
got to
I'm
move it
just
along
saying,
to the next
whether
one.
they like, I don't like their tenants either, and
Okay.
the traffic coming in, and the
Okay.
drugs, and so
All right.
it's a bad area, like my
Okay,
lawyer indicated.
we're done with your petition right now, so thanks.
Correct.
That's all.
It's a bad area.
Enough. Is there a videographer back there?
Yes.
Can we, I'd like to take a 5-10-minute recess. the record, this is again July 11, 2019. Our next petition is 4,810, Joseph M. Phillips, concerning property located at 8 Lindale Road, South Yarmouth, Mass. That property is in the zoning district R25. Our applicant seeks a special permit under bylaw 104.3.2, subparagraph 2, and/or in the alternative, a variance under bylaw 203.5 for proposed 15 by 18 addition and front setback. Good evening, sir. Would you tell us who you are?
Joe Phillips.
Thank you, Mr. Phillips. And what would you like to tell us about your petition?
We're looking to build a 15 by 18 addition to an existing bedroom on the first floor in a corner of the property facing Lindale Road, which, when the addition is complete, would bring it roughly 16 and a half feet towards the property line. It would still be inside an 8-foot stockade fence, and on the other side of Lindale Road is the vacant Windjammer Motel.
15 and 20. This is an
R25, right? R25?
25.
So, this is a front setback.
Oh, front.
Yeah.
Well,
So he needs 30 feet minimum.
Yeah, I got you. Okay, thank you. All right, was there anything else about the petition you wanted to tell us?
no, we've owned the house since 1960, and it currently has 5 bedrooms, and it would continue to have 5 bedrooms.
Well, where's the front of your house?
It faces, we actually have 2 addresses. One's 200 South Shore Drive, and then one's 8 Lindale. So the front of the house, from where the addition would be parallel with an existing screen porch, which is on a concrete foundation that's about 4 feet high. And that space from the front of the addition to South Shore Drive is 62 feet.
So the deck that's depicted on your site plan?
It's
is
already
your
there.
Front door? Or is your front door is adjacent to the deck?
Yes. You go out the front door onto the deck.
201 South Shore.
200.
200, I'm sorry.
Gotcha. Anything else you wanted to tell us about your petition? Seems pretty straightforward.
No, that's about it.
All
I
right.
think it,
So, Mr. Barron, any questions of our petition?
No. Note that the front setback is minimal, but it's similar to the existing 1475 from the existing house. So there's no substantial difference from the existing setback.
Anything else?
Oh.
Okay, Mr. Nicanella?
Yes, thank you. Well, it looks like a very nice project, and you're just doing some habitable space with no water or no nothing, or just you can have more room in your bedroom, I guess, right?
right.
Yeah, so there's maybe a little bit of heat, that's it?
The heat, no, we were going to put in a bathroom in there.
Or you are going to put
You're going to put a bathroom in, yes.
Okay. And it looks like I drove by it, the property is all surrounded by an 8-foot fence?
Correct.
About, you really can't see anything? Yeah, it's a corner lot, which makes it tough. That's all at the moment, Mr. Chairman, thank you.
Thank you, Mr. Hygo.
Have you had your septic system inspected lately?
Yes, I included that in there. I got it, it's inspected in 2015.
I thought I had it somewhere.
I actually have it here somewhere.
Oh, let's see what you got here.
And we,
So you say there's 5 bedrooms and there's 4, how many bedrooms are in there right now?
5.
And, okay, because I'm, let me just take a look here. Inspection, increase existing number of bedrooms. Well, your 87 septic system seems to suggest it only can handle a 3-bedroom. Am I looking at something wrong here?
well, I have an inspection here from 2015.
Okay. How many bedrooms you got on that one?
Does it say it on here?
It should.
Mr. Igo, the field card says 4 bedrooms.
Yeah, he said,
Her memo says that.
yeah, we've got a,
This says,
we have a memo from Amy Van Hoon. It says a research of the health department records indicates there's an eight, well, there, she references an 87 system. And then there were voluntary inspection report for 14.
right, 72314.
And it suggests that you made some upgrades to it at that point, distribution box. Broken
You
tank.
replaced inlet cover, replaced outlet T, replaced distribution box, town of Yarmouth permit fee. So $1,200 in 2015, October. Let's see where it says bedrooms.
Have you had any discussions with the Board of Health on this at all?
Yeah, we went to, is that what this is? Yeah, I got, they passed the septic. I'm trying to think of who I spoke to.
Bedrooms, so that's.
How many?
Oh, they knew there was 5. I'm trying to, I had a letter from somebody. Who would I have spoken to there?
We don't have anything that tells us.
Oh, right.
I don't think we do.
We at best we have a field card that says 4 bedrooms.
Right.
And then we have a memorandum from Amy Van Hoon, which says a
3.
research of the health department records indicate the following. 1987 septic system upgrade for a maximum of 3 bedrooms. Capacity as-built card submitted by septic system installer, meaning it was a plan given and an as-built card once it was completed. Voluntary Title V inspection report dated, that was probably when you bought, is that when you bought the property?
I bought it in 2016 from my mother's
Passing
estate.
on this property back in 14. It's usually why they would do this. But
Right.
in any event, there was a voluntary Title V inspection with the repairs that you noted done in July 2014. The third involvement is repairs of all issues stated in voluntary inspection were completed, meaning they inspected and approved. And there is a discrepancy between number of bedrooms upon comparison of health and assessor departments over numerous years. Per discussion with the owner, March 2019, Health Department has determined the proposed additions and renovations will not impact the existing septic system located to the rear of the dwelling, nor increase the number of bedrooms. Full review of the proposed work is required by the Health Department prior to final approval. Additionally, the owner will be required to provide a floor plan of the entire dwelling to place on file with the Health Department in order to clarify the actual number of existing bedrooms. So, I mean, that's just kind of strange at best, because I need to know, to my satisfaction, what that plan, what that existing site, septic system is qualified for. You know, because I'm concerned about my drinking water.
Right.
You know, and it's not in an APD, but these systems have to be accommodating, and they're rated is according to the number of bedrooms. And so if it's a 3-bedroom system, I can tell you right now, I'm going to have difficulty with it without a septic upgrade. If they say it's okay, but they don't tell me how many bedrooms it accommodates.
Can I ask you a question then,
Sure.
Mr. Chairman? If, and I'm not sure how we're going to fall down on whether we approve or not approve this, but if we were to approve it, could we not approve it with the condition that they comply with the Board of Health Title V regulations?
Sure.
For the number of bedrooms?
Sure.
Because that's more or less their
Right.
department.
And not to further complicate this, but I think part of the issue was that the second floor of the house always was wide open. There was no bedrooms ever. And then in 1984, no, they put rooms up there.
Oh, yeah.
So when growing up, we had, 8 beds up there.
Okay.
Well, this has been your family's home?
Since 1960.
Yeah. That's the way a lot of properties develop on Cape Cod.
Right.
Detriment of the Cape, you know? Sorry. But that's what we're trying to avoid.
And I think, and one of the issues that somebody told me at the town was that, you know, I don't know if you guys had a fire in the early 80s or something, but that the original building permit had been lost.
Yeah, that's happened.
So I actually had a picture of my father sitting on the front porch with a building permit over his right shoulder from that time.
Okay, Mr. Igo, did you have other questions? I'm sorry I interrupted.
So this addition that you're putting on another bedroom, is that what it is? It's
Well, no, adding existing, kind of taking off an existing bedroom and been replacing it with a wider and longer one.
Okay.
Replacement.
Okay,
It's a
so you're just replacing
Right,
it.
take it, right. We're gonna make the existing bedroom, which is like 9 by 9, into a, you know, closet and storage and.
Right, I see. Okay. That's all I had. Thank
All
you.
right.
Ms. Britta?
No questions, Mr. Chairman?
You know, I think it's a wonderful plan. Unfortunately, when you get these corner lots, we've had to deal with these corner lots before, and to say that merely because the side of your home is adjacent to a street doesn't suddenly make it the front of the home.
Right.
And so while you have to come here for relief, in my mind, it's good that you do come, but it's also, we have to take into account how we've dealt with these in the past. And in the past, we've always looked at it as no, even though there are two fronts, that one could say this house fronts on, two streets that one could say this house fronts on. In truth, there's only one, and we look at the other as the sideline. So I'm satisfied that the front of the house is 61 point some odd feet.
Right.
61.59 feet from the true front of the frontage of the house onto South Shore.
South Shore.
South Shore.
That's South Shore Drive.
I am concerned about the water down there, because, you know.
That's not South Shore Road, that's South Shore Drive, by the way. We gotta change that.
Oh, yeah, I saw that, and I was wondering why the heck that was. It's Drive.
Yeah.
South Shore Drive.
No, there was just
It says road.
it says road. I was
Oh,
just
does it
kidding.
really?
Yeah, that's all right. That's not big.
Yeah. So I think Mr. Igo's got an awfully good idea on how to deal with this prospectively, about if we were to grant relief to, to consider that the Board of Health would be have to give the final sign off on it.
Sure.
I'm sure Mr. Grillis is shaking his head back there going, that's a good way to do it. So does anyone in our audience care to speak in favor of this petition? If so, please come to the microphone, be heard. Seeing none, does anyone care to speak in opposition to it? Seeing none, we now close it to the public's commentary. We open up the board discussion and deliberations. Now, the wind out of the sail is kind of right there at the bottom of Amy Van Hoen's memorandum, where she says, we're satisfied, it's okay. But I think I think the easiest way is as Mr. Igo suggests. But, Ms. Barron, what do you think of the petition? Ms. Britta, I'm sorry. Ms. Britta, what do you think of the petition?
I think it's fine. I think it's fine.
All right, Mr. Igo, your thoughts on it?
I think it's a reasonable request. I think Tom raised a good point where he said it's really no further from that lot line than what the existing house is. There's only, I think it's less than a foot right there in relief that he's asking. If we treat this as a side setback, which in corner lots we try to do that because it's tough to put houses back 30 and 30 with two fronts and two sides.
Would you agree if we do that, we can treat it as a grant relief by special permit?
Yeah, we can grant relief by special permit on this.
Okay.
Did he ask for special permit? Ask for both? Okay. Yeah, no, I think it's a reasonable request. He wants to build a little bigger bedroom for he and his family, and he's certainly set back adequately from South Shore Drive. That appears to be the dominant setback in terms of frontage anyway when you drive by the house, because you look at it from that. So you make the corner at Lyndale, and I think that's more of a side setback on that side. I think it's reasonable, and I think if we just conditioned the grant of relief upon the Board of Health approving the septic, then we'll be fine.
Great.
Oh, wait a minute, we haven't gotten there yet.
Oh, no.
That's my opinion.
3 others that might say no.
Oh, I'm
Mr. Nicanello, what are your thoughts?
I think it's a very nice project. It's going to enhance the house. As long as we get rid of the 8 beds upstairs, I think
Right,
it should
there
be
you
all
go.
right. Yeah.
And Mr. Barron?
I agree. The plan is speaks for itself. It is good. I do think that the conditions that Health has suggested, particularly a complete building plan to help determine the septic loading, should be one of the conditions for the granting of the permit.
But would you be more specific? I'm not sure I understand. You want a completed building plan to be filed with us?
I think what was asked in
Yes,
the memo was some type of a plan that
It says
shows
in Amy Van Hoen's note, it says the owner would be required to provide a floor plan for the entire dwelling to place on file with the health department.
Yeah, and I think that goes in line with the Board of Health approving it, so.
Yeah.
I mean, that would be a condition of whatever conditions they have required for
Right.
approval. I mean, I don't want to be in the business of telling the Board of Health how to make their approval. That's my only point.
True. Where the present plans have been drawn up by a local professional designer, I think it should be an easy thing to accomplish.
Okay, so then we can say a full floor plan?
Well, at least a plan depicting the location and number of bedrooms. I think that's what they asked.
Yeah.
They just didn't have
Just
that.
reference this memo, because it's all written right there. Just reference Amy's memo of the date.
Yeah. If you want to, yeah.
All right, so yeah, I've got that, thanks. So why don't we require, though, that if he's going to do it, let's have him not only do it with the filing of the Board of Health, but also in Wildfire
Right,
as
so
well.
we have a number of bedrooms.
So you see what we're saying? You just
Correct.
need to have a floor plan of the premises
Yep.
drawn, showing the location of all bedrooms and returning it. And that would seem to satisfy the Board of Health concerns.
All right, great.
Okay. So I've got nothing I want to add. I think it's all been said perfectly. So all those in favor of a motion that's going to be made by somebody first, I guess, who's going to make that motion?
I'll make the
Mr.
motion,
Nicanello,
Mr. Chairman,
I
yeah.
knew you'd jump in.
Yeah, we'll make the motion in conjunction with the Board of Health comments for petition 4810 for the special permit 104.3.2, and it'll be a special permit, not a variance.
Okay, and is there a second to the motion?
Second.
All right, Mr. Barron, thank you for seconding. Now, I think that the relief, the only comments I do want to make is I believe the relief can be granted without causing any undue nuisance, hazard, nor congestion to the existing nuisance or congestion, nor a change or impact, or substantially impact or to the detriment of the current character or future character of the neighborhood or town. And I would suggest that that be incorporated into the findings of the board. Would that be fine with the motion and with the second?
Absolutely.
All right, so all those in favor, anybody want to have any conversation before moving it along? Hearing none, all those in favor of the motion, please indicate by saying aye.
Aye.
Those opposed? Carries unanimously. A decision will be drafted that gets filed with the town clerk's office. 20 days must elapse before it's considered final. That's a technical waiting period. I'm not anticipating any appeals in your instance. Assuming there be no appeals, that would then be a granted special permit, which would be in a form that you would have to take and record at the Barnstable Registry of Deeds, returning proof that you have recorded it to our board secretary, Ms. Sandra Clark, sitting to my left.
Great.
Okay?
Thank you.
Thank you very much, sir.
All right, thank you.
Thanks for investing in our town. Keep doing it, please. There are a lot of properties we'll be happy to see you make all of them better. All right, brings us to our last one. That is petition 4811, Yarmouth Village Condominium Association. I'm sorry this is last, because obviously there's some interest in this. I'm sorry we couldn't get you all home earlier, but in any event, we have Yarmouth Village Condominium Association for property located at 131 to 136 South Shore Drive, South Yarmouth, Mass. That property is located in the zoning district R25. See, they got it right on this one, South Shore Drive.
See that? Yeah.
That's nice. Before they had a South Shore Road. So this property is, tonight is our applicant seeking to modify decision 2090 to increase number of units from 39 to 46 and clarify on-site property manager duties. Please tell us who you are and what you'd like to tell us about your petition.
Absolutely. Good evening. My name is Matthew Gaines. I'm an attorney with the law firm of Marcus, Arrico, Emmer, and Brooks, and I represent the applicant, Yarmouth Village Condominium Association. Joined with me is Phil Baisha from the Board of Managers of the condominium.
Hi, Phil.
So this is in response to a violation letter from the building commissioner dated May 17th. The special permit that was issued back in 1984 for the conversion of this from a motel into condominiums set the maximum units at 39. The notice of violation from the building commissioner states that there's actually 46 units. At the outset, I guess I would say that I'm not really even sure relief is necessary, but as a abundance of precaution and probably the path of least resistance, we thought it best to ask for relief. As I said, the special permit allows for 39 units, and we think there are 39 units there. The reason why I think the building commissioner believes that there are 46 is because some of the units are set up to allow for separate occupancy by two groups, and therefore the building commissioner is the opinion that these units are actually two separate units. The condominium documents clearly show otherwise. Section 2 of the condominium's master deed states that there's 39 units. Exhibit B of the master deeds lists the 39 units in their descriptions. The special permit notes that the condominium documents were submitted as part of the application process back in 1984, and thus we assume the town was aware of all of this. The floor plans of the condominium that are attached to the master deed show the layout of the units and show sort of how some of these units sort of have two separate occupancies in them. And again, we assume those plans are all part of the application back in 1984. The units in question are units 1, 7, 10, 11, 13, 23, and 32. As part of the application, I did include the master deed, and at the end of the master deed are the plans that show the layout of those units. Each of those units has two separate entrances, so again, this is all out there and has been since 1984. The original plans clearly show the intention of these units to allow for separate occupancy, but still remain one unit. Having two living quarters in one unit, in my opinion, does not automatically turn one unit into two units. While we don't believe that relief is necessary, again, since the property only consists of 39 units, we felt that the best resolution was just to apply for the amendment to the special permit. I would note that the property has, as I said, from 1984, so 35 years the property has operated as it currently does with allegedly 46 units. You, I believe, have received many letters of support from unit owners there, saying they obviously do not oppose this and they support it. This request will not really change anything. And I think the over 30 years of operation as allegedly 46 units shows that the requested modification will not create an undue hazard, nuisance, or congestion. There will be no substantial harm to the established or future character of the neighborhood or the town. As such, we'd kindly ask the board to determine that there is no violation, or if it's easier, just to modify the special permit to take into account the unique nature of some of the units. That's sort of the first part of our application and the first, I guess, issue raised in the building commissioner's letter. There is one other issue that was noted in the building commissioner's letter and also noted in our application, and that is condition 5 of the special permit requires a full-time property manager on site. The building commissioner has not stated there's a violation of this condition, but rather seeks clarification of condition 5, as do we, frankly. Just quickly on this issue, for many years, the on-site manager, which is employed by the condo association, has managed the affairs not only of the condominium, but also all of the rentals. She handles all the tenants and the payments and everything, does both the management of the association and the affairs of the rentals for all the units. However, this rental season, for the first time, a handful of owners owners elected to use an outside company to manage the rentals of their units. We suspect perhaps this is the reason why the building commissioner raised this in his letter. Again, Condition 5 states that there must be a full-time property manager on site, which has been the case for many years. What is not clear, though, is whether it is permissible for owners to retain an outside entity to manage some of the units. The outside entity that has been retained by a handful of these owners is neither full-time nor on-site. We would simply ask the zoning board to clarify Condition 5 as it pertains to the rights of owners to retain outside entities to manage units. We did submit, as part of our application, a sort of a job description of the property manager's duties and responsibilities, just for your information. That is really all I have. I'm open to any questions.
That was wonderfully and succinctly stated.
I thought so. You're welcome.
So refreshing. Mr. Barron, any questions of our petitioner?
Why are some of the units considered dual occupancy?
They have two entrances, and there's actually, if you look at the plans on the units I listed, there's actually a solid wall separating one half from the other. You can't get from, I think all but one of the units is like that, if I'm not mistaken.
What's the nature of that wall? Is it a firewall?
Do you know what it is? No.
No, it's
Just a partition?
You have to speak into the mic.
Oh, sorry.
Just a partition with no doorways?
Right, that's it. It's a solid wall that separates, for example, 13 from 13A.
Is it in any way rendered soundproof with additional soundproofing material?
Not that I know of. Most of these units were non-conforming when it was approved back in '84, and unless there's been, unless they had replaced that wall, I would guess that they haven't added any kind of soundproofing.
What sort of conditions prompt the idea of the dual entry, and who is the party that occupies the second side of any
I believe that most of the units are rented there. Obviously, some people could use their units. It is a seasonal units as well, April to October, I believe.
But assuming there's one family or one group that occupying the first side, who controls who's occupying the second side? Is that through the association?
It'd be, the owner of the unit.
Yeah, in the case of the example I gave of 13 and 13A, that's handled by our property manager, who actually is behind me, and she handles the rentals, and it would be rented separately, in essence treated like a two-unit owner, under one property. The 4 of these A units are being rented through this outside property management group, and I don't know how they handle.
Yeah, that's a separate. That basically is a separate issue.
Sure.
But,
okay.
But essentially, what you're saying is that so-called dual unit is really 2 units, not a single unit.
Correct. They could be entirely separate people in the A side from the other side.
So the building commissioners claim that these are more units than originally.
It has
allowed.
merit. Yes. Yes, but the odd thing is that the plans label them as one unit. If you look at the plan, it doesn't show it as 11 and 11A. It just shows it as Unit 11, and so on and so forth for the others.
I see that the plans may indicate that, but that's not how it is.
Understood.
How it's functioning.
Which is why we applied for the abundance of precaution. We applied for the modification of the special permit to increase the number from 39 to 46.
Okay. I have no further questions on that, but I do wonder why it, or would like a response. Do you think that a more complete site plan, not the plan that shows in the master deed, which shows scattered units. Do you think a more complete site plan might help with the understanding of how the entire complex, the entire association is being organized and managed? In other words, a single map showing all of the...
I think there may be that already. I mean, again, the plans are attached to the, I think probably just for size, frankly, they couldn't fit everything on one sheet when they did that. But the plans that I submitted that were attached to the original master deed does show the layout and location of all the units.
But nothing, they're shown separately.
Sure.
I'll forego a further comment on that.
Wrote this decision. Maya Singer wrote it, huh?
I'm sorry, you were done.
Yes.
I apologize. Mr. Nicanello.
Yes, thank you. Good evening. Who makes up the Board of Managers?
It is an elected board. They're elected by the unit owners. How many members are on your board?
Five.
5 members.
Is there any documentation from the Board of Managers that the on-site property manager would be extinguished?
Be fired?
No,
Oh, I'm
it's
sorry.
just gone. I mean, it appears
Oh.
that it went from an on-site property manager now to people owning their own condo and doing their own thing, but I don't see any documentation from the Board of Managers allowing that.
No, actually...
Correct.
Yeah.
Silly question to have, thank you.
Why is that?
Why does the,
Why did you allow them, following up on that question, why did you allow them to separately rent their units when it's clearly not permitted?
that is an excellent question. And I would not necessarily say that we have. It is somewhat a matter of dispute. They're doing it. We're somewhat allowing it. It has been rather contentious for the last few months, starting actually back in even October or November, I think is when the issue first came up.
Yeah.
There's some language in the condominium documents that is not abundantly clear on the topic, frankly. It could be read to allow for separate management, or it could not be. Obviously, that 2 attorneys disagree on the issue.
Mr. Chairman,
No, not right now.
Excuse me?
No, not right now.
Okay, I represent.
Well, that's fine. We're going to give you a chance to speak, but not out of order.
Fair enough.
The concern that I have is, what if 39 or 46 unit owners now decide they're all going to be their own property managers?
Yep.
How do we
Agreed.
control that?
I agree it's a problem.
This sounds
That's-
like a family dispute to me. I don't know that it's really.
Agreed. I mean, obviously, there are certainly advantages to having one management company, particularly someone there who is on site and sleeps there and is there 24/7 and can deal with issues that come up. If there were 46 different management companies, that would certainly make it more difficult. I agree. And that's to some extent why we're seeking some clarification on that condition 5. Whether or not you want to
Geez, you know,
dip your toe into that water.
I go and I don't do much real estate, but I always thought that the law worked on the plain and simple usage of words. That's neither here nor there. Maybe I'm wrong.
If it did, then attorneys wouldn't have jobs.
Well, I got a job, and I still believe it. Anyway, go ahead.
I just want to get back to the, were you done, Tom, by the way? I didn't mean to cut you off. All right, because I was. Now, getting back to the units that you want to say are 2 units and not 1 unit, 1, 7, 10. I'm looking at unit 1. You get 600 square feet, 2 bedrooms, living room, 2 bathrooms, and a kitchen. Is there only 1 kitchen in unit 1?
So I assume you're looking probably at
Master deed Exhibit B.
Exhibit B.
Yeah.
But or you can answer the question, but if you also look at the plans, I believe there are 2 kitchens in that one. If you want to answer, Phil.
Well, this is Exhibit B. This is the document necessary for you to determine percentage of ownership.
Yep. Phil, do
So,
you
I mean,
wanna-
it's a pretty important document.
I agreed.
Yeah.
Go ahead, Phil.
Yeah,
You wanna-
you're talking 1 and 1A, they have separate bathrooms.
Separate kitchens?
Separate kitchen areas, yeah.
Okay.
Are those studio units?
Yeah.
Oh, so if you sort of look at the plan that's also attached to the back of the master deed, where it shows unit 1, you'll see that it says living room, bedroom, and bath on I'll call it the right side, and you'll see the solid wall, and then living room, bedroom,
What page are you
bath on the left side.
Can you tell us what sheet that's on?
It's towards the end of the master deed. So after Exhibit B, that chart you're looking at, there's a few pages of floor plan. Yep.
Which one is what?
That is page 3, sheet.
C what?
I'm looking, they all say C-166 at the top.
Oh, yeah, I'm sorry, yeah.
It says the one that.
They're not numbered, those
no.
pages.
Okay, then just give them to us a number from the back.
Yeah, it's the third plan in order going from Exhibit B. Shows the one for Unit 1.
Yeah.
Okay.
Third from the front of the document, yes.
Third.
Building A.
Correct, yep, you have it. In the,
Is it that
it's
one
the
right?
long building. Yes, yep.
What,
Seeing
you want me to?
units 9, 10, and 11.
Yep, and then the long building at the top of that plan, or depending which way you're holding it, is on the right-hand side of that, you'll see there's a 1 in there.
Oh, yes, sir, thank you.
You're welcome.
Where are you seeing it?
600
that
square
can-
foot, right there.
You want a magnifying glass?
The sooner I get, the more I need
Do
it.
we have the actual large plan in the, or is this how it came through?
Well, this is all that he.
This is what's recorded at the
You have
registry.
The original plan is what he's
Do
saying.
I know from 1984? I do not.
Well.
I assume these
we
plans
have
are.
it here. Let's see if we have it here.
Yeah.
Well, are we looking at the manager's quarters right here?
Yeah, is Unit 1 the manager's
Right.
quarters?
No.
No unit?
Oh, that's that one.
Yeah.
Okay.
Oh, yeah, it's on the other
So
side there.
here
That's
is,
the original.
here are,
Where is this located on the property?
This
With
is.
this particular unit?
Yeah.
Yeah.
I know the property quite well.
You
Where
do,
is it on
okay,
the
yeah. As
property?
you're driving down the street, you see the sign Seaside Cottages on the right.
Yeah.
It's on the right.
So you're where check-in is on the right.
That's it.
Okay, so it's
Yeah.
adjacent to that.
It's- yeah.
Okay.
Yeah.
here we go.
Yeah, we refer to them as the motel units because their parking lot is around it.
I'm hoping so there, Sean.
I would think
Just
it
forgive
would.
us, we're trying to locate the
Oh, wow.
larger version of
Sure.
what's attached.
Impressive that they still have that from 1984.
That's the map I was looking
Well, that does show that, man, this'll,
Well, I think we're gonna get better ones as we go.
well, I don't know if we're gonna show that one because it's across the street. This is the one on the beach side, but we've got some of those units on the beach side too. All right, so this plan you're showing us for Unit 1, I don't see any kitchen in it.
It's a studio. It's a
But you
studio.
said there's 2 kitchens in it.
Yeah, they're like a little kitchenette thing against that solid wall area outside of the bath area. That's where it's located.
And there's no pass-through door between those 2 units?
No.
Is there a pass-through
No,
door?
there's not.
No.
So you can only rent half of it. You can't choose to rent the whole and have interior access.
Not interior access. You'd have to go outside to get to the other side.
Right there.
It doesn't help us. Sure doesn't help us much, but takes a
I mean, there is some writing there that says future door.
It does, yeah, I see that, but it does not exist. It's
Okay, so the future never arrived on that.
correct.
Now, where are the other ones here? We've got,
Units 1, 7, 10, and 11. So 10 and 11 are on that same page that we're looking at if you want to stick with that one, so we don't have to go hunting for another plan.
Yeah.
And again, you can see as you're kind of this U-shaped or C-shaped, depending which way you're holding the thing, you see 11 there. And again, there's a living room, bedroom, bath, kitchen, closet, and you'll see again a solid wall. And there's sort of entrance, you can see the 2 separate entrances from one half to the other.
Yeah, now, those are located on the beach side. Just
I've
keep,
got
But they're
units.
described in the master deed as 2-bedroom living room combinations.
Yep.
2-bedroom living room combinations, bedroom, 2-bathroom kitchen.
So there are technically 2 bedrooms, there's one on each side. And again, the drafter of this was certainly not.
Not you.
No, I'm not.
I'm calling you.
Yeah, I did not draft this. I was not an attorney in 1984.
I want you to read it. It says.
I agree.
2-bedroom living room combinations, that's the plural.
Yep.
Bedroom, 2-bathroom kitchen.
Well, what I think it's referring to a bedroom, living room combination is that is one room. It's, again, a studio situation.
Between the two words.
Excuse me?
Is the hyphen?
Yeah, there's a hyphen. So I think that's what they're saying, is that the room is a combination room. That's
All right.
how I'm reading
I want
that.
you to read and tell me what that means. Are there 3 bedrooms there?
2-bedroom, living room combinations. No, I read that to mean there are 2 bedrooms. Those bedrooms, though, can also be living rooms, because they're a combination of a bedroom and a living room, which is customary for a studio. Oh, I agree. The description is not well drafted.
Living room, bedroom.
And if you look at the plans,
Living room, bedroom.
it sort of mirrors that language where it says living room / bedroom on the plan. On one side of that Unit 11, and then on the other side of that solid wall, it says the same thing, living room / hyphen, whatever you want to call it, bedroom.
So this plan shows us 1 bath.
1 bath on each side of the...
And can you come up and identify that on the original plan?
I can, hopefully.
1 bath on each side.
I mean, there's Unit 7, it's got 312.
I'm looking at 11 right now.
Okay.
Where's 11?
Well, we can find 14, 13, 11's right there. 356 square feet.
So this must be 11, right?
Now, Unit 11 on the master
Still have to
deed,
have you pull a mic closer to me.
yeah.
Sure.
Still your
Unfortunately, the people that see it sitting out
Sure.
there at
Unit
home can't
11.
figure what you're referring to.
Building D. So it says Unit 11.
Yeah.
So it must be this one right here, right? So it says bedroom BR/LR. So that's that room.
Yeah.
And then you have the bathroom, the closet, and then this is the solid wall, and then this is the other half of 11.
Well, that says 10.
Well, again, I don't know. It's not, well,
Is that
or,
unit- can
oh,
I
no, I'm
ask-
sorry. You know what? It's over here.
Yes, it's
No, wait a
an
minute.
extension. It's an extension. It's not.
Sorry, go ahead, Phil.
The best way to do this is really to get one of the old timers up here. I'm only been around.
No, you know what we're going to do? We're going to go
Okay.
back to the table.
Okay, sure.
You guys don't have a plan. No. We're going to go back to the table, and if you guys don't have your videos, your art to help us with this problem, we're just going to look at what we have here. Okay? Because we have people at home that are actually
Sure.
interested in all of this.
Okay.
And we're going to make a record. We're not going to make a record of you saying here.
Sure.
Nobody knows
Absolutely.
what it means.
Absolutely.
Okay? So we're talking about, I thought we were talking initially about 10. Isn't 10 one of the 2?
10 is one of the units as well.
I want to
Correct.
stick numerically if we
Okay,
can.
yeah,
We've looked
sure.
at 1.
Sure.
Now if we can go to 2. Number 2
no.
is 10, right?
No,
Well, 7, if you're
seven
going in order.
Is the
Number
first,
7.
yeah.
Where's 7? What sheet? No, but what sheet?
Which, it is on, so again, on the plans in the master deed, it is the first page of the plans.
No, but it's not in this one. I was just asking what sheet. I get what you're saying, okay.
This,
Yeah, all right, thank you.
Down in Building C.
Let's go to this one.
That's not it, Tom. I don't have it.
I don't know
first
that
sheet?
I have that sheet.
Yeah, on the back of the actual deed.
Okay.
First
Exhibit
sheet.
3.
Okay. Where are you showing that one, Susan?
right here, on the second, on the very first.
All right, gotcha. 7.
You got it?
Yeah, 7 is right after 6.
7 is a 2-unit.
This is 7
Set.
and 7A.
Yes.
7 is, really, I'm going home at 10, so. 7 is 2 units, right?
It is 2 separate occupancies.
2 units.
Yes,
Okay, and I'm looking at a plan, and help me with this now.
I will try.
7 is 744 square feet.
Yes.
Looking at a bath to, I'm going to call it my right, forget the compass for a minute.
Yep.
I'm looking at a living room, bedroom, living room, bedroom, living room, bedroom, and a second bath.
Correct.
Do I have that whole thing right?
I believe you do.
Where's the second kitchen?
Are there 2 kitchens in 7, Phil?
I see 1 kitchen. Where's the second one?
There is.
You're renting it as 2 units, right?
There is none.
There is none.
I'm being told.
So you have a rental unit that has no kitchen?
Is there a kitchenette? kitchenette?
Kitchenette.
Kitchenette on one half of
The
it.
installation of that approved with by the building permit? By pulling
It's-
a building permit?
I suspect that kitchen has been there since 1984.
But it's not on.
But it's not on the plan they showed in 1984.
I don't know if kitchenettes are usually on plans.
You showed a kitchen.
Well, we showed probably the full-size kitchen, but I don't know if a kitchenette would be on a plan. Because this just shows the layout.
You
This
didn't
doesn't
show.
I mean, it doesn't show a toilet, it doesn't show, it just shows the layout of the building. It doesn't show the location of sinks and everything.
Okay, but in 1984, there was there was relief required from this board in order to create what is there on the ground today and the configuration that's on the ground.
Correct.
When you went from 52 units to 39. And I know, either by having known them, though some of them are no longer with us, or having known of them, many of the people that sat and very thoughtfully considered that grant that these owners looked for, that created the decision from what you're now trying to seek modification.
Sure.
Right? And they gave thoughtful consideration to a set of plans that talked about a reduction from 52 to 39. Right?
Understood, yep.
Not however many more, 46 are we talking about now?
Yes.
And part of it, as I read the decision back then, was predicated upon a belief that the parking would be, better parking would be facilitated. Better flow of traffic through the units would be facilitated. And now we have parking for 46. Do you know if that meets our parking load?
I don't know, because I had not looked at your parking table, admittedly, but I can tell you they've not experienced any problems with parking.
Well, okay.
No, your point is well taken. If it meets we can certainly look into that. But as far as I know, there's never been issues with parking.
Okay, let's go to the others.
Can I ask just one other question? Is this what's recorded at the Registry of Deeds?
Yes, yep, it's attached to the back of the master deed, correct.
Well, I'm just curious why you have different numbers on this than you do on this. You've renumbered all the units.
I don't know what that is.
This is a plan.
I assume that's probably what was submitted with the application.
No.
Oh, this is
No.
1982.
Oh, okay, so that maybe that was not the final plan.
Okay, that might not be the final plan.
I don't know.
I think these were the final plans.
Go ahead.
And they took these final, and they went down with the linens and recorded the linens down at the registry.
Well, yeah, typical. Yes, the Mylars would be at the registry, the original.
The unit that's closest to the beach parking lot, right there in the corner when you cut through to the Skipper, you always had it as a linen closet. What's that right now?
That's still linen. You're talking about right across the street from Skipper's.
Right.
Yeah,
Right
that's
there
still,
on the corner of
that's
that
still
unit.
the linen shed. That's what we use that
Okay.
for.
All
Yeah.
right. All right. So that's not a unit. Okay. Well,
Can you tell me which is the smallest unit that is now two rental units?
I could, give me a second. So Unit 1 is 600 square feet, Unit 7, 744, Unit 10 is 772, Unit 11 is 658, 13 is 563, so at the moment, that's the winner. 23 is 704. It looks like it is Unit 13, which is 563 square feet, according to the master deed.
these units that you want to go from 39 to 46, specific units, are those specific units, for instance, 7A and 7B, are they owned by the same person, or are they?
Yes, so that's a good point. There's one deed for those units, and when we refer to the A and B, it is more informally in the sense that if you look at Exhibit B of the condominium documents, which lists all the units, it just says 7. It doesn't say 7A and B. The A and B is more for internal notations when people are renting it or there's issues, but there is one deed for that unit.
One deed. Okay,
One-
so you're not asking for additional owners.
Correct. And it couldn't be sold separately. You couldn't sell half of it currently.
Well, I presume that, but when you're going from 39 to 46, in my mind, initially, you're creating 7 more units.
Then potentially we could. So if there was this modification to bump it up to 7 more units and make these officially A and B units, then in theory, maybe there could be an opportunity for someone to sell
Are there any
one half.
restriction in these master deeds that prevents that from happening, selling 7A and 7B off in separate ownership?
At the top of my head, I don't know the answer to that. But if the master deed were amended to create those 2 units, then they would be 2 separate units.
As long as we said you could do that.
Correct. Yes, obviously.
So potentially what you're asking us for is 7 more owners. Because if we grant you the right to do 46, I'm just hypothetically saying, I'm not saying.
I would think, though, that you could also,
Condition that.
yes, that's what I'm thinking.
Yeah.
They're separate units in the eyes of the town, so to speak, but still with one owner. Can't be subdivided in terms of ownership.
And that would be the way to go.
All right.
Hey, before I pass it to Ms. Britton, just one question before I forget.
Sure.
Have any new bathrooms been created?
Since when?
Since we have now 7 new units with A and B designations.
Not that I know of.
No.
No.
Okay.
No.
I apologize, Susan.
That's all right.
I just wanted to
That's
get
all
that
right.
question out.
This is fascinating.
before supper, so forgive me.
So just to clarify, going from 39 to 46 is reconciling practice with reality.
Correct.
Good way to put it.
Sean mentioned the notion of, once we do that, conditioning that by saying 2 units but 1 owner. And a
Correct.
condominium association, because that would, if you do 2 owners, you've got parking issues, you've got all sorts, you get bad enough
Correct.
issues now with people running off getting their own property managers. This would make it worse.
Correct.
So I think that's a good, that would be a good suggestion. So the clarification really is reconciliation from
Yes.
practice to reality.
Yes.
Okay. The property manager situation.
Yes.
There had to be an action forcing device that all of a sudden last November, a bunch of people said we don't want to have the property manager. Where is the fuzziness in the language? What exactly led people to believe they could go off and do this? Because I think it sort of breaks down the whole notion of a condominium association.
Sure.
There's economies of scale. You want the place to look nice. You want the landscaping to be sort of homogeneous. You want one place to go file complaints. It makes a lot of sense to have one, especially since you've got a ton of small units.
Yep.
What is the fuzziness in the language that allows?
Sure. So obviously, there's the special permits language that says there should be an on-site, and I don't really know if that's fuzzy or not. But in the bylaws, in an amendment to the bylaws of the condominium that was actually adopted back in 1990, there was language.
Have, right?
What's that? No, I did not submit that.
We don't have.
I do have a copy. Sorry, I apologize for not submitting that. But it states that in terms of the powers and duties of the Board of Managers, I will just read this to you. It says, the powers and duties of the Board of Managers shall be the leasing, managing, and otherwise dealing with the units on behalf of the unit owners for the purpose of renting units for the benefit of the unit owner. Said authority shall include, but not be limited to, advertising units for rent, obtaining the services of rental agents and staff, maids, linen services, opening of bank accounts, collecting of rents, deducting expenses, payments of rent to unit owners, preparation of budget records, and other activities necessary for proper leasing and management of the units. Here's the key sentence. This, however, shall not be construed to limit an owner from individually renting his unit.
Well, it's very clear then. You gave them the authority to do it.
So did you have
Why they did that is beyond me.
Well, the argument, the issue is, what does that really mean? Is that in terms of
You gave them the authority to go get their own rental agent.
Well, see, you could argue that 2 ways. You could say it says to limit an owner from individually renting his unit. Meaning, if I were an owner there, I can put my unit on Airbnb, VRBO, Craigslist, whatever it is. That's me individually doing it. That's me managing it. That's me collecting the rents. That's me changing the linens, whatever it is.
Not hiring an agent to do it for you.
Exactly.
And splitting hairs, but individually, when you have a real estate agent, they're acting on your behalf, so.
I'm just reading the language.
I would have a meeting of the condo association and strip that sentence from
And as I said, that was adopted in 1990 and has been, until recently, there's been one manager who did it all. And I think a couple of people would occasionally do it on their own.
There was one, we have one owner who advertises her unit through VBRO, but all the services are provided by our property manager. So there's no conflict of who's on site showing up with trucks and whatnot, delivering things to that unit for linen or cleaning and whatnot. This all happened this year, and it started just at the annual meeting that we had at the end of October. Somebody just announced that we're leaving the association, and they walked out.
You know, forgive me before we go too far afield with this discussion, but why are we being asked to be a court?
Because the building
How are
commissioner...
we to decide what the interpretation is?
I simply raised it because it was in the violation notice from the building commissioner.
I mean,
And I don't think the commissioner...
to sit here and try to
Understood. No.
take care of this cat and dog fight.
A fair point. And again, the building commissioner raised it. He didn't raise it as a violation if you read his letter, which I did include in there. He just...
If he raises a violation and finds you, then you can appeal that process.
Sure. And he hasn't done that. He just sort of...
I mean, that he's wrong.
Threw it out there. So we felt the need to respond to it.
But I think the only thing we're talking, you present us a master deed. You all do an amendment that we don't participate in. We're not going to solve your cat fight.
Understood.
Okay?
Understood.
In terms of what is the definition. At least I'm not. Are you inclined to do that?
Absolutely not.
Well, the only thing that I might just interject on that is, I'm not quite sure if that amendment in 1990 didn't violate your special permit.
Yeah, I mean, that's for them to problem.
Which I think it
Let
might
them
have.
go to court and argue that out, quite frankly. I don't
Yeah,
think
and again, the building commissioner can correct me if I'm wrong, but at the moment, I don't believe there is a pending violation as to Condition 5. Mr. Igo, your point is well taken, that he could take the position that we are in violation of Condition 5 because of what is currently happening. But at the moment, and again, the building commissioner can correct me if I'm wrong, but my reading of his letter and my conversation with him after that was that there is no violation of Condition 5.
Would you agree that the master deed that was approved in 1984 had no such amendment in it?
Oh, of course. That's without argument.
The only definition we're looking at is that which is contained within the 1984 master deed and bylaws. Would you agree with that?
Well, the bylaws have been amended, so
what? We haven't been asked to pass
Oh, no, agreed. I'm just saying that they
have a right to do that.
They are a matter of record. That is a legal document. So as far as the owners having, my client and the owners having to comply, they have to comply not only with the orders of the town, but also the governing documents of the condominium.
I know, but let's talk logically for a minute. A 1984 decision is predicated upon the submitted the submitted bylaws and master deed, right?
Correct.
The definition of on-site manager is set forth within those bylaws.
I wouldn't say definition. There's wording that says there needs to be an on-site manager.
Yeah, which is usually,
which there is. They have an on-site
doesn't
manager.
define on-site manager as being someone over age 21 with two eyes, two arms, and two legs.
Of course, but it also doesn't say if that on-site manager must manage all of the units or.
You're right.
Yes.
Would you agree with me that that's a matter that is not within our purview to decide?
Unless there's a violation before you know, correct.
Okay, so now there's a violation in front of us.
Well, there isn't.
Well, somebody's apparently interpreted that there is a reason for violation.
Well, there is no violation. Again, the building commissioner, correct me if I'm wrong, but I don't believe there's a pending violation of Condition 5. If you read the building commissioner's letter from May, he does not say this. He was seeking clarification, and that's all we're doing.
Personally, I don't want to.
Thinking there may be a thing. If you choose to punt on that issue, then I guess it maybe goes back to the building commissioner to decide what he wants to do with it, and then he could.
Sounds to me like you have two groups vying with each other, and you want us to determine the litigation that the two groups might have. I mean, I don't know that I'm inclined to do that.
Well, I would personally, I don't want a situation where there's 46 property managers down there. I want somebody to be able to pick up the phone if the town needs to call the property manager. I think the spirit of the original agreement was that there was going to be a property manager.
To me, it's clear and unequivocal language. What's there to interpret?
So if you're asking us, or if you're asking me, do I think that's a violation of Condition 5? My answer is yes.
Okay. I think that's
One property manager.
And I think that's what Mark was concerned about. There's a possible violation.
You want to hear from Mark on that?
Sure, Mark can come up and tell us all he wants, but they're asking us to opine and resolve a 1990-plus amendment to the zoning bylaws that was never considered by this board in the grant of the relief. So why would we even get involved in that discussion?
Well,
you didn't come to us and say we're amending our bylaws.
The only reason
Mark is going to Mark might violate him on that.
Well, that's fine. Violate him. I think you're probably justified.
Well, now that I understand it better, I probably will. The number 5 was prompted as a result of an email that went to the town administrator claiming that we're not doing our job by inspecting all of the units. Why was one particular person required to have an inspection? We do an annual inspection of the property as a result of, for them to get a certificate of inspection. When I followed up with my inspectional services staff, they said we couldn't get in those units because they were locked. The on-site manager only had access to half of them. So that's what prompted this number 5. Number 2 sets the maximum number of units at 39. The definition in the zoning bylaw of a dwelling unit, as well as in the Mass State Building Code, clearly states what a dwelling unit is, and it's a single unit. I got that somewhere in the pile. A single unit providing complete independent living facilities for one or more persons, including permanent provisions for living, sleeping, eating, cooking, and sanitation. So there is definitely relief required for the over 39 units because they are clearly dwelling units by definition. So,
Spoken to that at all.
no, in the beginning there was discussion by council.
Well,
I'm not suggesting that we don't need to grant
No, absolutely.
relief to do or not give grant
Okay.
on that. We're talking about why we need to define for them what their meaning was between under a 1990 bylaw amendment.
Correct.
Why are we being asked to do that? We didn't participate in this. Nobody in this board did.
Right.
Not back in 1984. What would be our reason for doing it now?
Well, it's just for clarification.
My personal belief is you're justified
Right.
in going ahead and citing them. But that's my personal belief. It's got nothing to do. How do we even?
I really wish
consider
council was still here.
To rewrite the bylaws for you?
No.
We'll give you a definition to what's there in your bylaws and your amendments to them?
I think they just are looking for us to clarify number 5.
The duties of the
Clarify your number 5?
No,
Oh,
the
the
condition 5 in the
Condition number 5.
1984 special permit, yes.
Okay, an on-site manager.
Right.
Exactly as was stated. So I think we're all going to be pretty much in agreement on that. So let's go now to the other. I mean, Jesus, I'm sorry, guys, but I'm missing what you're having us do here tonight.
So,
because I just don't think.
we're really the only thing we actually asked for in terms of relief is the modification of the 1984 permit to increase it from 39 to 46
Then
units.
let's stay directed on that.
Yeah, I'm happy to.
So, Mark.
Yes, sir.
You have cited them for that, have you?
Yes, sir.
Okay,
That's a
and how
violation.
what have you done? Have you enforced the violation?
No, I gave them 2 weeks to file an appeal with the board, and that I stopped.
Okay. All right. Anybody else from the town want to speak before we go to everybody else's input? Seeing none. Is anything else the petitioner wants to offer?
Not at the moment.
All right, seeing none. Anybody have any questions of the petitioner before we move along?
Chairman, are abutters allowed to speak?
Absolutely. I'm going to do it in order, though, the same order we do with every single petition. So, does anyone in our audience care to speak in favor of this petition? If so, please come to the microphone and be heard. Come right up, sir. I'm glad to finally get you up there.
Thank you.
I know you want
My
to get
name is
home,
Stephen
too.
Hayes. I'm an attorney. I represent the so-called handful of owners who have decided to engage a separate management company. I'm speaking, I'd say, more or less in concurrence. But anyway, the handful of owners actually own 12 of the 39 units. So it's basically a third of the condominium has decided to go the separate route with respect to rentals. A couple of real quick procedural things I note in the application for hearing. It states the applicant is the Yarmouth Village Condominium Association, and they're identified as the owner of the property. The Yarmouth Village Condominium Association doesn't own any real estate. The owners of the 39 units own the real estate. So again, that should probably be other interested party, whatever. The notice went to them, so they responded. I'm just noting that for the record. I would concur, basically, going back to the original special permit, it basically did not deal with rentals at all. It simply allowed a cottage colony in single ownership to be converted to a condominium with 39 units. And that's what was approved, and that's what happened. And I think we're getting into a little bit of semantics between what's the unit under the condominium law, which is clear. It's what's defined in the master deed and the floor plans are recorded with the master deed, and what's a unit under the building code. So, you know, I concur with my brother that it needs to be, there are 39 units, however, these 6 units have 2 separate dwelling areas, whatever, you know, however we want to go. So I certainly agree with that. The on-site property manager, there is an on-site property manager. She's there full-time. She has 2 different functions. One of them is to operate the condominium, common areas and facilities, collect the dues, deal with emergencies, things like that. She does that for all 39 owners. I would submit that because of those duties, she is in full compliance with the. We are within full compliance with the special permit as issued. I just want to clarify that. There seems to be some thought that these owners of the 12 units have totally taken themselves out of the condominium as far as operation. That's just not the case. They're still operating. You know, everything is being run as far as the common areas and facilities. Monthly dues, insurance, everything else is being operated that way. Before my clients went to took this step, and if I may,
Sure.
This is,
Thank you. Thank you.
Thanks, Steve. Thank you, Counsel.
Thank you.
If you look at on the 3rd page of that, one of my clients actually approached Mr. Grilla back in about a year ago. Actually, a year ago. It was a year ago yesterday, believe it or not. He responded July 10th, 2018, and they were inquiring, could we, under the special permit, actually engage separate management or manage the rentals of individual units separately from the association? And he went on to say, and I apologize for the quality, but he says, after review of the decision, there's nothing indicating that the ZBA required a management company to be the sole point of contact for rentals. However, it indicated, and he goes on to say it's obviously seasonal. So,
Where is that?
It's the last page. It's an email.
Unfortunately, poor copy, but
It's a poor copy, and I tried to think as much as I could.
Very at the very top.
Yeah.
He's
I got it. Got it. Okay.
Well, can I just ask a question? Because
Sure.
when Mr. Grills wants to go and inspect the property, and he's told he doesn't have a set of keys.
Okay.
How is that not having more than
Okay.
one property manager?
Okay, the property manager for the association has keys and should have keys to all 39 units. The fact that she didn't at that time, I'm not sure why that happened. It should not have happened. She should have access and does have access as under her duties under the bylaws of the condominium. So she essentially wears 2 hats. She's a rental agent for some of the units, and she is a manager for the condominium association. So she should and does, I believe now she does have access, keys to all the units.
Do you want me to respond, or?
Just a question,
Phil, do you know that we're going to
Sure.
ask?
Yeah. What happened was this group hired an outside company. They came in and took out the locks that were on the doors, put in their own locks, and left. So our property manager did not have access to these units for a period of time. We, through our attorney, required them to go back and take out those locks and put back the locks that were originally installed so our property manager would have access. They did it for some units. They didn't do it for all units. We had to send them multiple complaints and to push them to change. And this is one of the issues with this property manager thing. If we're going to have multiple people controlling things, it creates a chaos on site.
So there's no language in the original master deed relative to rentals and the managers?
I don't, as of 1984, I don't believe there was anything with respect to rentals in the master deed. There was an amendment, I believe, correct me if I'm wrong, it was what, 1989?
1990, I believe.
There was an amendment which basically authorized the board to manage rentals of the units, and then there was a later amendment which clarified that individual units, as any individual owner of real property, had the right to handle their own rentals of the units. And, my contention, when we went back and forth with this, is they tried to say, well, that means you can, hang out a shingle yourself and change your own sheets and clean your own toilet. But I said, no, if I own real estate, I can engage an agent to do it. We settled the matter, at least with respect to these units, and they allowed, we agreed that this separate management company could come in and manage just the rentals, the coming and going, what's within the unit, is collecting the money from tenants with respect to these 12 units. That was an agreement we reached with the Board of Managers. Meanwhile, the existing property manager still has all of her responsibilities to all 39 unit owners with respect to common areas and facilities, landscaping, all those things that are put in, parking area, that's all theirs. So, and again, I would submit that under the circumstances, we're still in compliance with that. And just one other, quick thing to point out as far as our current managers not being on site, or our rental managers not being on site. 1984, we didn't have email, we didn't have cell phones, we didn't have texts. Now we do. If a tenant has a problem within their unit, they can get on the phone to the rental manager, and somebody will be there immediately. They manage hundreds of units around Cape Cod. So anyway, and again, I think that's process. They're not on site as a rental agent, but again, we have people on site
So if
for the
there's
property
an
manager.
emergency, they still go to that
Yes.
on-site manager?
Yes.
But the on-site manager wouldn't necessarily respond because they're not engaged for that purposes.
I mean, I guess it depends what the emergency. I guess it depends what the emergency is.
Can we just go back, please, just because this is becoming ridiculous.
Yeah, okay.
Here is the simple and unambiguous language of condition number 5. Full-time property manager, nothing about rental agent,
Yep.
on site during open season, living quarters provided as an association expense. What do you wish us to qualify about those words? Because there's nothing before us asking us to modify this decision based upon this. You're asking us to give you a definition of these words. What is it you want us to really, please tell me. What are we going to clarify? Please. The petition that you have presented this evening, and I'm going to read it as presented. Amend existing special permit issued in 1994 to change the number of units from 39 to 46 units and to obtain clarification on duties of on-site property manager. I'm sure you meant of. Yes. But how are we going to tell you what the definition of an on-site property manager is? It's clear in unambiguous language. I'm not here to debate it. And I'm not here to tell you if you can have a property manager also be a rental agent. That was not even considered by the decision, guys and gals. The decision doesn't weigh in on it, nor does the master deed, nor do the bylaws. Now, you all have a changing world, and I understand that. But there's nothing unambiguous for us to clarify. So until you want to come in here with a petition asking us to modify it, I don't know what relief we can possibly give you.
Again, Mr. Chairman, the sole purpose for my including that in the application.
By the way, I'm not angry with you.
I understand. It's been a long night. I've been to enough of these hearings. I know if you're the last person on the agenda, what to expect.
My wife often says to me, "Are you angry with me?" No, I'm just arguing.
Yeah, no. Mr. Chairman, the sole purpose for including that in the application before you was as a result of the wording in the building commissioner's letter. That is all I can tell you. He didn't say there's a violation. I'm not saying there's a violation. That's all I can tell you. And if you want to just punt on that, because there is no real request before you.
As us punting.
Well, I'm sorry. I didn't mean that in a negative context.
I don't see how we can provide you clarifications for words which are not ambiguous.
I suppose just because, to play devil's advocate, one could argue that does full-time property manager on site mean just for the management of the affairs of the condominium, or also for the management of the rentals?
And in my opinion, you'd have to come before us to ask us to modify that provision.
Fair enough.
By saying that we now wish to have an on-site manager also be construed as the rental agent.
There shall only be one. Yeah, and maybe my client will decide if we want to make another application in the future to do that, but currently that's not before you.
But you're asking us to clarify something that
again, it's only
to say the words so that maybe you don't get into lawsuits.
It was just. Go ahead.
Yeah, I'd just like to say one thing regarding this, and that is this property was always a rental motel type operation. When it was condominiumized, it was for the rental usage. That was clear in the original language in the petition before the board. It was never intended to be a residential kind of property. At that time, it was run by a person as a sole proprietorship, and then it was handed over as a condominium to this Horan, who I don't know anything about him whatsoever, but as far as I know from the people who've told me, they've owned here for over 30 years, there's always been a property manager because of your requirement that there be a property manager, and that the property manager's role was inclusive of what typically is included in a property manager, and that is that they're responsible not only for the common elements, but for if there's a business orientation, which is this does have, this is a rental property, that's what the property manager is also responsible for. And so I think the confusion really came around this condominium because of this amendment, not from the original decision. The original decision seems very clear.
But we have nothing to do with the amendment. That's the logic. You see, now logic is coming to the forefront.
Oh, yeah, no, I agree completely with what you're saying there.
How are we going to weigh in on something you people amended back in 1990? Let's move on, can we?
Sure.
Again, I'd like to actually go home tonight.
Me too. That's great.
I'm not saying it to be funny. I'm saying it to be sincere. Let's get to what's really at issue.
Yeah, the request
which is 39 or 46.
The request to modify to 46.
Just pass a resolution addressing that one issue and remain silent.
We can address whatever you want.
There's no request.
We clarify would be
and again, reading the application, there's really no request. It's just sort of saying, hey, we're here tonight, so let's talk about it. If you want to talk about it, if you don't, thanks. Have a nice night.
Are you asking us all to weigh in with our personal opinions then?
No, I was just, again, it was just because of what was in the letter from the building commissioner. That was all. So we can certainly move on from that
I think
topic.
the building commission has to decide is there a violation. If he decides it's a violation, you have a right to appeal from that decision in whatever manner you want, which would be inclusive of coming before us and asking us to modify the decision of 1994 relative to the very simple and unambiguous.
Agreed. So I think we can just push that off the table until there's a violation pending.
Now, getting back to the number of condos?
The number of units.
Let's get back to that, because let's go to the decision from which there was an appeal. Mr. Hayes, did you have more you wanted to chime in on?
No, thank you.
Okay. Well, wait a minute. Let's before we. Does anyone else wish to chime in favor of anything we've talked about so far? Because you're only going to get one chance.
But we're not going to talk about the manager, only the units.
The back of the room.
Does everybody agree with that?
No.
Mr. Chairman, in the back of the
Come
room.
right up and tell us what you want to tell us about the number of units, because we're going to not deal with
My
the
name's
other.
Glenn McKenzie. I own Unit 13.
Hi, Mr.
I just didn't know if you're going to review that unit as you did the others.
Is yours on the?
He's one of
13
the.
and 13A.
Is this one scheduled for review too, Glenn?
It's one of the 7 units.
One of the 7 units.
Oh, I see.
Because at one point we were going through them unit
You were
by
going
unit,
through
and then
them,
we.
and then you stopped.
Yeah.
I just want to make sure you review ours Because it is very clear what's on the plan and what's there today.
Yeah.
Okay, so
all.
let's take a, wait a minute, before you leave, let's take a look at what's clear on the plans. 13?
13.
Because I'd like some clarity to some of this, because I read a decision where they turned this down. They turned it down because it was going to be, because 47 units were planned on this site, okay? And then the board was sued. And then they came back with 39. That's the real history here. So we're only one shy of what they turned down in 84. You're 13?
Unit 13 would appear on the first page of the plans attached to the master deed.
Right in the center of the page.
Exactly.
Thank you, sir. Yeah. Okay, thank you, Ms. Britta.
And there are 2 kitchens shown, one on each side, to be precise.
Right.
There you go. Good luck.
13 is where again?
Right in the center of the page.
It shows 2 kitchens, 2 bathrooms,
Right. Right here.
and 2 living areas.
There's 2 baths.
Right here?
Right there and there. There's the kitchen, there's the kitchen.
Just show me
Oh, I
13.
see.
Oh, there it is.
And there's a solid wall that divides, and there's no way to get from
Oh, yeah.
one side to the other.
And you own both of them?
Well, it's on one deed.
Yeah, again, it's one deed, one
On
unit.
one deed,
Deed, but 2 units.
that's how we purchased it. You know, and when we
It's 2 separate units.
2,
2 completely separate units on
Okay,
one
thank
deed.
you. Thank you. That's
Does the
very
deed
helpful.
describe it as 2 separate units?
It
or
does.
just- It does.
in your unit deed, but it only calls it unit 13.
Only
It
calls it
doesn't.
as 13.
It doesn't call it unit
And the
13 and
percentage of ownership
13A.
And the square footage, sure.
Yeah.
Okay.
The square footage is the total of both sides.
Right.
I mean, if they're going to be held as, if we conditioned a decision that they have to remain as, if you sell them, you got to sell them as one unit. You can't split them up and sell them as one and one.
We were told that when we purchased it by an attorney, that we cannot divide them and sell them separately. We were told that originally.
Yeah.
I don't frankly see what difference does it make if you got 2 or you got. What's the issue?
Yeah,
The issue
I
is
know.
still, there's only 39 full units. They're all described. They're all still laid out with the same number of bedrooms. Is that correct?
Yes.
And but for a kitchenette, which I guess I could put in my bedroom, in my master bedroom if I wanted to, right? A microwave, no, we don't yet. A microwave and a cooktop. I could put that with a little mini fridge. I could put that in my bedroom now, couldn't I, at home? That would constitute a kitchenette that you have there now? Although there's a little sink. There'll be a little sink.
In the toilet.
It's a big deal.
Single-family dwelling unit.
What's the benefit of going from 39 to 46?
Yeah, I understand
Just
what you're
to,
saying.
just.
I'm not in violation of the special permit.
I think the reason that they're asking us to do that is because Mark
Oh, I understand why they're asking to do it,
is
sure.
viewing these as separate dwellings.
Yes.
Right,
Yes.
right,
Make
okay.
it consistent with the state definition.
Right.
Interestingly, though, they had one that was exactly configured as it is now, shown on those 84 plans that were approved, and recorded with the master deed and the bylaws at the Registry of Deeds, showing exactly the existence of one unit, but 2 separate living facilities within one unit. Geez, that's a real telltale thing in my mind. I don't know about anybody else. But.
Well, it's a little strange, but, I mean, for purposes of making it easier for Mark and complying with the state building code, I think we may just consider this a housekeeping matter and just, let's just kick it up to 46, because we're not increasing any square footage, we're not creating new owners. There's a restriction that they gotta be sold together, purchased together, it just, there's no zoning violation.
Yeah, I mean, the condition could easily just say, any unit which has a separate dwelling cannot be separately sold or something. I mean, we can work at the wording, with you on the wording on that, certainly.
Well, we'll get to the precise wording in a minute, assuming that somebody wants to make a motion. Well, wait a minute, before you do, though.
Yes.
Please. So the tenor of the discussion on the board right now is that we would likely grant relief modifying that 84 decision so as to acknowledge that there are, how many units, 7? 7 units that
have
comprise
dual
2 separate living quarters within the living unit, Does anybody wish to speak in opposition to that sort of relief if granted this evening? And seeing none, we now kind of close it to the input from everybody out there. And what a nice group of people you all are.
Really, you're the only one with an edge.
Damn right I got an edge. Frankie, I haven't had dinner yet. All right, so let's go back to how we now fashion this. Would it seem to make some sense that we put a distinct difference between the words living accommodation, the living quarters versus domicile? Is that the word you're hung up on, separate domicile, Mark?
Dwelling unit.
Dwelling unit. So that we, boy, how do you redefine the obvious? Huh?
Well, you can just make them 2 dwelling units held by one person.
So that restriction on ownership continues.
That cannot be subdivided or divided, I should say.
And that is consistent with the bylaws right now, is that correct? Is that
Yeah, I mean, you could say that, any unit, because it's, the word unit obviously I think has different meanings in the eyes of the building commissioner than in my eyes being a condominium attorney, where I think of the condominium unit, which is what is shown on the plan and described in the documents, versus a unit in the eyes of the building code, obviously is slightly different in this particular situation. It's a potato-potato type of deal where they're not necessarily the same thing.
How about this? If we identify the 7 units that we're talking about,
Yep.
we say that those condominium units may be comprised of 2 separate and distinct living quarters.
dwelling units?
Would that suffice?
I would ask the
Dwelling units.
building.
That would make it consistent with state law.
That would make it so easier on you, Mark, that you wouldn't have to have equivocation in your decision not to cite?
I don't have the original decision or the condo docs in front of me, so I don't know if it references dwelling units to 39 dwelling units, or does it say 39 living units? And I think
I will
that's...
tell you in 1 second. So Section 2 of the master deed of the condominium says the building contains 39 condominium units. Condominium units. And I believe in the decision...
It shall remain only 39.
In the decision, in the condition 2 of the special permit, just says that it has a total of 39 units.
So how about 39 condominium units not subject to subdivision, but allowed in the
But units send blah, 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 blah.
Be allowed to contain 2 housing
Units. I think that
How's
works.
2 separate dwellings.
2 separate dwellings.
Dwellings?
That takes care of it for Mark.
I like it.
So can I make a
Phil?
motion?
Sure.
Good.
Mr. Igo.
I'd like to make a motion that we approve the special permit or the amendment to the special permit
4811.
by increasing the number of dwelling units from 39 to 46. You want more than that?
Because I want to clearly
With the
state it
condition, with the condition that they cannot be
Condition that they cannot.
severable.
with-
Any units,
Well, how about,
sorry.
how about this? You've only got 39 owners, right?
Well, some people own multiple units, so I mean, there's 39 unit deeds. Some people own multiple units, yes.
But why don't we just do it this way?
You had the exact language before, why wasn't anyone writing it down?
That there remain 39 condominium units.
Yes.
Of which the designated 7 are allowed to be comprised of 2 separate dwelling units.
Correct.
And that
And
they'll,
that and of those 7, they may not be sold, they may not be subdivided for purposes of sale.
or sold separately.
Or sold
Yep.
separately.
I believe that works.
Okay, great, you can draft the decision.
I can only write so fast, so I don't know if I got all that down.
That's the motion.
Huh?
That's the motion.
That's the
I'll
motion.
second the motion, Mr. Chairman.
was going to second.
Oh, I'm sorry.
Mr. Barron? Ms. Britta might like to.
Would you like to second?
Ms. Britta's smart. She doesn't want
I'm
any
working
part
on
of
the
that.
condo document.
Yeah.
All right. So we're clear on the language, what we're talking about?
I think so. I didn't.
Units,
I
39.
didn't really write it all down. But
Remain the
yes.
same.
Right.
7 are going to be identified, subject to 2 dwelling units. Those are the words you're going to use. That satisfies Mr. Grillis. Make sure we keep those words in. I'll look forward to your draft.
And the notion they can't be sold separately.
Yep.
Okay?
So you want me to? I'll draft it and send it over to.
Send it to her. She'll send it
Yep.
to me.
Thank
On
you.
that motion so made by Mr., does everybody understand the motion with the stated conditions? On the motion made by Mr. Igo, seconded by Mr. Barron, does the board care to have any discussion before moving along to a vote? And hearing none, all those in favor of that motion, please indicate by saying aye. Aye. That carries unanimously. When I get a decision, I promise you I will review it right away,
Thank you, Mr. Chairman.
then be filed with the town clerk's office. 20 days must elapse before it's considered final. Assuming there'd be no appeal from that decision, you would then need to take that modification decision. And by the way, does the board agree with me before we leave that relative to so much of the petition that asks for clarification of the words on-site manager, or however it was phrased, that we are not going to proceed with that,
No
any
action.
determination of that? Does the board agree with that?
Yes, no action.
Correct.
Holding you, Mr. Nicanello, as well? Huh?
I refer to the original decision.
There we go. I like that. That's the way it should be.
Yeah, pretty clear.
Okay, so the board has voted unanimously on that. Thank you very much.
Thank you, Mr.
all in
Chairman.
attendance. You've been a charming group tonight.
Becky Green document.
We're afraid we were going to get banana peels thrown at us.